Moving on to open session. No apologies have been received? Nope. Any other apologies been received or notice from any members to delegate authority to other members of the committee to vote under temporary standing orders? Nope. Nope. Declaration of interest. Members are obliged to declare any relevant financial or interest at committee meeting as applicable. I have one to declare. I had a meeting with a member of somebody who's representing RIFCA, which is the Reserve Forces Cadets Association, and there's a letter of correspondence related to that later on during the meeting. I'm a bit old to be a cadet, but it wasn't. I just wanted to make that as a declaration of interest. Any others? Yep. On item number 3, Chairperson's Business Fiscal Commission. As previously agreed, I met informally with the Fiscal Commission on Tuesday in order to discuss their interim report and forward work programme. Things we discussed super parity, VAT issues and the Northern Ireland Protocol, economic inactivity in Northern Ireland and the devolution of income tax in Scotland. And the committee will hear formally from the Fiscal Commission later today.
Chairperson. Stephen, would you mute Pat, please? Thank you. Sorry, Chairperson, you were saying.
Oh, it's quite nice to listen to Pat's constituency manager. The Fiscal Commission has provided a copy of its presentation, which is at tabled items. Is the Commission content to tweet this so that people viewing this meeting can follow proceedings more easily? I think we're agreed. Agreed. Draft minutes of the Finance Committee meeting on the 12th of January are at page 8. Members who are content with the draft minutes of the 12th of January and accurate record of proceedings? Agreed. Happy to move on. There are no matters arising. Agreed. Moving on to the Defamation Bill, can we invite Mike in?
Excuse me, does that have to ring in here if we don't need to know there's votes?
Good point. Well,
I don't think you can switch it off. It's through the whole building.
We'll ask.
Oh, Mike.
Hold on.
Welcome, Mike. Welcome to the committee again. Members, I just want the following papers relating to this agenda item. The Clerk's briefing note at page 19. The Defamation Bill table update is at page 23. Correspondence from committee to the bill sponsors at page 63. Ministerial response to previous related correspondence is page 67. The Defamation Bill and the EFM as introduced are at page 127. And at page 4 of the tabled item is a copy of the bill sponsors amendment. And do we all have those in front of us? Okay. I just want to inform members the session has been recorded by Hansard. Mike is here to answer any questions about his amendments. The bill clerk is also available to provide advice if necessary.
She's there.
Barbara's there. Barbara's there. Hi, Barbara. Okay. The committee will proceed through the clauses and I will put the questions formally. Where there are amendments, the questions on the amendment will be put first and then the question on the amended clause. Members should follow this process using the updated bill table in their meeting packs. However, only those amendments which the committee previously agreed to consider will be put. The wording of those amendments from the bill sponsor is in tabled items. If members are unhappy and want other amendments to be considered, they should indicate this clearly in good time if that is clear. If that is clear, are we happy to proceed? Okay.
Chair, also just to clarify, since I wrote that note, the bill sponsor provided some other typographical amendments, so those will be considered as well if members are content with that.
Okay, we're content?
Yep.
Okay.
Chair, just for clarity then, the bit of paper produced is amendment 1 to 16 and the additional one at the back.
Yeah, and that one I think fits in at
Clause 10.
Clause 10. Thank you.
Okay. Right. Are we ready? Let's go. Okay. First one, Clause 1, serious harm. This clause at page 23 provides that a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. The provision extends to situations where publication is likely to cause serious harm in order to cover situations where the harm has not yet occurred at the time the action for defamation is commenced. Members. Okay. Yeah. Members, are we content that we understand Clause 1? Not whether we agree with that we understand Clause 1. Okay, agreed. The committee previously informally agreed that it would not consider related amendments and would simply consider whether the clause should stand part of the bill. Okay. Okay. If members are content with this approach, I think we are. Okay. The question is the committee content that clause 1 as drafted stands part of the bill? All those in favour say...
Sorry, Chairperson. Do members need to vote on this?
Yes.
They do. Okay,
Yeah,
sorry,
we do.
Chair.
That's all right. I'm sorry. I'd already got to that point. Right. What was that?
Don't know. Let's rock and roll on. This is going to be okay. So we
Okay.
can see the members now anyway. So.
Okay, right. Let's get ready for this one. Okay. Right. For clause 1, those in favour of clause 1 say aye.
Aye.
So,
Put your hands.
Show of hands.
Show of hands.
1, 2, 3,
3,
4. Okay, 4.
Okay. Those against?
1, 2, 3.
4, 5. That's Gemma. Okay.
Motion negatived.
So the notion is negated. Okay, move on to the next clause, clause 2, truth. Clause is at page 29 and replaces the common law defence of justification with a new statutory defence of truth. The clause is intended broadly to reflect the current law while simplifying and clarifying certain elements. Members, do we understand clause 2? We do. The committee previously informally agreed that it would not consider the related amendment and would simply consider whether the clause should stand part of the bill. Since that informal agreement, the bill sponsor has proposed an amendment which corrects a typographical error. This is shown in the table items as Amendment 1. Okay. Which is clause 2, page 1, line 919. Okay. So, members, are we content to, sorry, do we have any questions about Amendment 1? Okay. Therefore, is the committee content to amend clause 2 in line with the wording in tabled items? Is this agreed? Agreed? Okay. If agreed and if members are content, is the committee therefore content that clause 2 is amended stands part of the bill? All agreed?
Lovely.
All agreed? Excellent. Okay. Clause 3, honest opinion. The clause at page 31 replaces the common law defence of fair comment with a new defence of honest opinion. The clause broadly reflects the current law while simplifying and clarifying certain elements. It does not include the current requirements for the opinion to be on a matter of public interest. Members, do we understand clause 3? We understand it. There are 2 possible amendments that have been suggested to this clause and were informally supported by the committee. These related to reasonable belief and are set out in the tabled items from the bill sponsor. These are amendments 2 and 3, and there's also a typographical amendment, which is at Amendment 4. Members, do we have any questions about these amendments?
Chair, I
Go
have
ahead,
a question
Jim.
about Amendment 3, which wants to add as a subparagraph C, any fact that the defendant reasonably believed to exist at the time this statement contained of was published. I want to know the reference to any fact. Is that something which objectively is a fact? Or can it be something which in fact turns out not to be a fact, but is reasonably believed by the defendant?
Mike?
That would be a matter for the judge, because it would be a subjective decision as to whether it would be reasonable to have believed that it was a fact at the time the statement was published.
So when the word any fact is written in that amendment, it's any fact if it turns out to be a fact?
Reasonably believed to be a fact.
Yes.
And this is wording that was lifted from Professor Scott's recommendations.
Which I don't know if I'm allowed to comment at this stage or not.
You can. Yeah.
It seems to me that's not advisable, because that's a bit of a... Anyone can say, oh, I reasonably thought that.
Would you prefer any statement the defendant reasonably believed to be factual at the time the statement complained of was published?
I think the problem's still the same. A defendant can simply say, oh, I reasonably believe that to be the case.
Surely a judge will not take that at face value and will say, why did you reasonably believe that?
Well, I think, you see, when you look at the category of 3, subsection 4, A and B are very definitive. They are facts which existed at the time the statement was complained of. B, anything in a privileged document asserted to be a fact. Those are very definable, authenticable facts. We're now into the territory of a defendant having the let-off of saying, oh, sure, I thought it was right.
Again, I think it would be the role of the judge to test that. But, Chair, may I ask, I mean, you took evidence from Andrew Scott. I did read the evidence, but I can't remember whether this issue was raised and what he had to say about it.
He didn't comment. I don't think members raised it at the time.
No.
Chair, it sounds like the committee is okay with amendments 2 and 4, but 3 is an issue.
Yep.
So,
Well, that's my position.
Okay.
yeah.
So therefore, are we content therefore amendments 2 and 3?
2 and 4.
2 and 4.
2 and 4, sorry. Amendments 2 and 4.
Is that agreed?
Is that agreed?
Great.
Yeah. And amendment 3. Views on amendment 3. Jim, you're against?
I'm against it.
Any others?
Yeah, I'm against it.
Okay. So I need to
To the vote then?
put it to the vote. Right. All those in favour of amendment 3, raise their hands.
1, 2, 3, 4, 5. I can't see Miss Dolan. 6.
Gemma, is your hand up?
We can't see you.
Yeah.
That's right. 6. So it's 1, 2. Sorry, members, could you just do it again?
Okay.
1, 2, 3, 4, 5, 6, 7. Looks like.
Okay.
7 for aye and no.
Against?
Is 1 and 2.
2. Okay.
So therefore, that one is carried.
That one is carried. Okay. Therefore, put the question on the amendment clause. Is the committee therefore that clause 3 stands part of the bill as amended? Is that agreed? Agreed.
Agreed. Okay.
Okay. Clause 4, publications on a matter of public interest. The clause at page 34 creates a new defence to an action for defamation of publication on a matter of public interest. It is based on the existing common law principle established in Reynolds v Times newspaper and is intended to reflect the principles established in that case and in subsequent case law. Members, are we content we understand clause 4? Yes. Is the committee content that clause 4 stands part of the bill as drafted? All those in
Yes.
content? Agreed. Okay. Clause 5. Right. Operators of websites. The clause at page 36 creates a new defence for the operator of websites where a defamation action is brought against them in respect of a statement posted on the website. Members, do we understand clause 5? Do we? The committee previously informally agreed that it would not consider the related amendments and would simply consider whether the clause should stand part of the bill. Since that informal agreement, the bill sponsor has proposed a further amendment which is shown as Amendment 5 and links to Amendment 14, which is about tidying up regulation-making powers. Mike, would you like to talk to that?
I think it's just technical, Chair,
Okay.
on advice from the Bill's office.
Okay. So, members, do we have any other questions about the amendment? Okay. Therefore, is the committee content to amend clause 5 in line with the wording in tabled items in respect to amendment 5? Is this agreed?
Great.
Agreed. Therefore, members, is the committee therefore content that clause 5 of the bill as amended? Is this agreed?
No.
Put that to the vote then.
Put that to the vote. All those in favour of clause 5, raise their hands.
1. Sorry, hold on. So stop. Sorry, Chairperson, members put their hands down. Sorry, it sounds like there's dissenting voices. Mr. O'Toole, do you require clarification?
My view, I think, on clause 5 is that we are supportive in principle, but we still want, so I think we will register an abstention on clause 5. We were certainly not opposed to it. We were in favour of principle. We wanted to a little bit more investigation into clause 5. So I don't think we'll be taking a formal position on clause 5. So I want to register an abstention.
Okay, right. I'll call the vote again. Those in favour of clause 5, raise their hands.
That's 1,
Okay. Those against clause 5, raise their hands.
2, 3, 4, and again,
Is that Gemma?
5 and 6, I think, yep.
Okay. And abstaining?
2.
Okay.
Really good.
So therefore clause 5 is negated?
That's right.
Yep. Okay. Move on to clause 6, peer review statement in scientific or academic journals. This clause at page 40 creates a new defence of qualified privilege relating to peer-reviewed material in scientific or academic journals, where published in electronic form or otherwise. The term scientific journal would include medical and engineering journals. Are we content we understand clause 6? Yes. Is the committee content that clause 6 stands part of the bill as drafted? Are we agreed?
Agreed.
Agreed. Okay. Move on to clause 7. Reports, etc., protected by privilege. The clause at page 41 amends the provision contained in the 1996 Act relating to the defences of absolute and a qualified privilege to extend the circumstances in which these defences can be used. Members, do we understand clause 7? Understood. If members are content, can we put the question, is the committee content that clause 7 stands part of the bill as drafted? Are we agreed?
Agreed.
Agreed. Okay. Moving to clause 8, single publication rule. The clause at page 44 introduced a single publication rule to prevent an action being brought in relation to publication of the same material by the same publisher after a 1-year limitation period from the date of the first publication of that material to the public or a section of the public. This replaces the long-standing principle that each publication of defamatory material gives rise to a separate cause of action, which is subject to its own limitation period, the multiple publication rule. Members, are we content we understand clause 8? Content? The bill sponsor has proposed an amendment which corrects a typographical error which is shown in the tabled items of Amendment 6. Any questions about Amendment 6, committee? Okay. Therefore, if the committee are content, in that case, is the committee content to amend clause 8 in line with the wording in tabled items? Is this agreed? Agreed. Okay. Therefore, if members are content, is the committee content that clause 8 stands part of the bill as amended? Agreed.
No,
Right.
no,
Hold
Chair,
on, sorry,
I want
Chair.
Sorry. Go ahead, Jim.
I just want to indicate I want to reserve my position on that. I want to think a bit more about it. So if there was a vote, I would have abstained.
Sorry, I think maybe the continue.
But I'm happy for that just to be noted.
Alicia?
You're voting on the clause now.
Yeah.
We oppose it.
Okay, you're opposed.
Okay, so
I oppose
the
it.
wish to vote on clause 8. So
Okay, wish to-
so when the chair says, is that agreed? Helpful if members indicate, no it isn't, need a vote.
Okay.
Yeah.
Okay. Clause 8. Therefore, clause 8. Those in favour of clause 8, raise their hand.
Sorry, just call it again. Sorry, Chairperson. So we're at clause 8.
Clause 8.
This is the one about single publication. So those who wanted to stand part of the bill, if they'll clearly indicate by showing their hands. So that's 1, 2. That's 2.
No, 3. Matthew's got his hand up.
Oh,
as well.
right. Okay. Members, if they'll indicate clearly and in good time. So 3 in favour and no. Sorry.
Okay. Those against?
That's 1, 2, 3.
3. Okay. And those abstaining?
Is 1, 2, 3. Okay, so we're tied.
Draw,
That means
right.
it falls.
Okay.
Okay, so it falls. So the motion therefore falls. Okay. Next
Okay, move on to clause 9. Action against a person not domiciled in the UK or a member state. This clause at page 46 aims to address the issue of libel tourism, a term which is used to apply where cases with a tenuous link to Northern Ireland are brought in this jurisdiction. Members, do we understand clause 9? Okay. Right. The bill sponsor has proposed amendment 7, which simplifies the clauses and corrects a typographical error and restricts the provision to those not domiciled in the UK and removes reference to the EU and states contracting to the Lugano Convention. This is set out in the tabled items. Okay. Members, do any questions about the amendment? Okay. Members, therefore, if members are content, is the committee content to amend clause 9 in line with the wording in the tabled items? Is this agreed? Agreed.
Agreed.
Okay. Therefore, is the committee therefore content that clause 9 as amended stands part of the bill?
No.
Disagreement. Okay,
Right, so-
go to a vote. Therefore, those in favour of clause 9 as amended standing part of the bill, raise their hands. Say aye. Raise
1, 2, 3,
4, 5.
sorry,
Jim Wells.
sorry, okay, then, sorry, beg your pardon, so it's 5.
Yeah. Okay. Those against?
1, 2.
2. And those abstaining?
Sorry, Chairperson, can the Sinn Féin members hear us okay? Yes, so Philip, Gemma, can you hear us okay? So are you, okay, I think we may have to call this one again, Chairperson, sorry, so.
Okay, all those in favour of the clause, raise their hands.
1, 2, 3, 4, and 5, thank you, members.
Correct. Those against the clause, raise their hands.
That's 1, 2, 3,
4.
there we go,
Does that make 9?
it does.
Good, right, okay.
So the clause is, that goes through
That goes through.
as
Okay.
amended.
Clause 10, action against a person who was not the author, editor, etc. This clause at page 48 limits the circumstances in which an action for defamation can be brought against someone who is not the primary publisher of an alleged defamatory statement. Members, are we content we understand clause 10? Agreed. One possible amendment has been suggested to this clause and was informally supported by some members of the committee relating to the definition of author and publisher, and it's set out at page 9 of tabled items. Do members have any questions about this amendment?
Sorry, is this the
This is the extra one at the
back?
Yes.
Yeah, I'd just like Mike to maybe talk us through it.
So the current proposal was to replicate Section 1 of the 1996 Defamation Act, which gives basically a single line to author, editor and publisher. This is a much more detailed exposition of what we understand by those three definitions, those three terms.
So it's all about defining author, editor and publisher.
Yes, and to make sure that, for example, a boy doing a paper round cannot be trapped as somebody taking part in an act of defamation.
Can a printer be trapped?
Yes, a commercial publisher.
Yeah.
As in publisher means a commercial publisher, a person whose whole business is issuing material to the public.
Yeah, sorry, to be clear, if I send a defamatory article to a printer
Yeah.
and they print it, no,
No, but they could at present.
sorry,
At present, they could be held. They've published it.
I don't think so.
I think there's been many as a publisher pursued.
Is there a difference between a publisher and a printer?
Well,
Yes,
the act
well,
of printing is to publish.
Publisher would be expected to know exactly what they're publishing. Whereas, is it reasonable if I've written, say, 1,000-page treatise of a scientific document, is a printer under the same obligation to understand every single word?
Surely one of the reasons why on all our election communications you have to say published by your election agent, printed by, because there could ultimately be liability on the printer. Is that all right?
Mike, in sort of 10.3 in your amendment, it says a person shall not be considered the author, editor, or publisher of a statement if he is only involved in printing, producing, distributing, or selling printed material containing the statement. So basically, they're just the vector for getting it out there. Okay.
So
And then in
is it
processing, making copies, or distributing, exhibiting, or selling a film, a sound recording as defined of the Copyright and Patents Act.
Yeah, so again, is it reasonable for somebody who owns a bookshop to be considered to be part of a defamation if they're stocking 2,000 titles, one of which happens to have a defamatory comment on page 753?
Not if it's not reasonable for the printer to be liable.
No.
I would have thought the printer can and should be liable.
I think that's a very onerous task to put on printers.
So Jim, are you objecting to the amendment in clause 10?
I think I'm going to be objecting to both them. Well, I think ultimately I'm going to be objecting to the clause, so whether it's in its amended form or it's, and I agree its amended form is actually more easier to understand probably than the original form. So
Okay.
I'm not opposed to the amendment being approved, but I want then to, I think, oppose clause 10
Okay.
as amended.
Well, in that case,
Can I ask a question, Chair?
yeah, go ahead, Matthew.
Yeah, this is a basic question. It just wasn't clear from our conversation, or indeed quite clear from the table papers. The amended clause, the new clause 10 in our table papers, is that tabled by the bill sponsor?
Yes.
Yes. Okay, because it's just not, because there are other ones from the bill sponsor. Okay, fine.
Okay. So, first of all, the amendment to clause 10, are we content are we content to amend clause 10 in line with the worded amendment?
Yeah.
No.
Hold on, so we're putting that to the vote.
Yeah.
Okay, right, putting this to the vote, right. Those in favour of the amendment to clause 10, raise their hands now.
1, 2, 3.
Yeah.
All right.
In favour of allowing it to be amended, yeah.
Yeah.
So it's
Yeah.
1.
Yeah, yeah.
Okay.
So
So,
we're voting on the amendment?
Chairperson, we'll just take a break for a second. So it's just so that members understand what we're doing here. So Pat, you can put your hands down for a second while I just talk you through this to make sure we understand.
This is the amendment.
So we're at clause 10. It's the amendment.
I'm sorry, it doesn't seem very complicated.
Pat, you've frozen, and unfortunately, yes, you're frozen with your hand up. So hopefully you weren't voting
For everything.
Oh dear.
Right.
We may
Mike
be
says, keep it that way.
All right now.
Actually, I don't think you
I don't
are.
think,
My hand is up.
No,
No,
you're
it's
not.
not.
You're sticking. So look,
I'm sure I'm voting in favour.
right, okay, we haven't put it to a vote.
Sir, can you hear me? I am voting in favour.
Okay, we haven't put it to the vote yet, Pat, but your vote has been, we shall do it now, just to get to this point. Right, we are voting on the amendment to clause 10, okay? Right, all those in favour of the amendment to clause 10, raise their hands.
that's 1, 2, 3, 4, 5, 6. 6.
Okay, 6, okay. Those against the amendment to clause 10, raise their hands. 1, 2, 3.
Okay, so that's 3. Very good.
Okay.
Very good. So
Okay.
the amendment
Sorry,
passes,
Chair,
but
what's the numbers there again? Many votes,
6-3.
6-3, it's now.
but I abstained.
Beg your pardon. Right,
I
sorry.
didn't vote at all.
I beg your pardon. But
Yeah, I
sorry
just
about that.
wondered
No
if I-
dissenting voices. I'm sorry, members, yet again. We'll have to have another go.
Right,
Beg your
okay.
pardon. No, it's my fault.
No, right.
I
Everybody,
think you did count,
this is to the amendment to clause 10. Those in favour of the amendment to clause 10, raise their hands.
Right, it's 1, 2, 3, 4, 5. Only 5.
Okay. Hands down. Those against the amendment to clause 10? 1,
3.
2, 3. Okay.
Right.
Those abstaining?
There we go.
Okay.
Passes. No, very good.
Right,
Apologies for that.
right. Having therefore that we have agreed to clause 10 as amended, therefore, are the committee content that clause 10 as amended stands part of the bill?
No.
No. Okay, so we shall put that to the vote. Those who are in favour of the amended clause 10 standing part of the bill, raise their hands.
1, 2, 3, 4. That's it.
Okay. Those against?
1, 2, 3, 4.
Those abstaining?
That's the one. It falls.
It falls. Okay. Okay, the bill sponsor has proposed a further amendment, which is the insertion of a new clause 10A. Does this stand at clause 10A if
Well,
10 is...
it's just the numbering. No, it doesn't
Okay.
actually relate to
Okay.
everything.
This is shown as Amendment 8 at the bottom of page 6 of the tabled items and relates to judicial discretion in respect of the alternative disputes resolution. The committee previously informally agreed to give further consideration to such an amendment. Do members have any questions about the amendment? This is particularly the issue to do with the...
Yeah, alternative dispute
Dispute
resolution,
resolution.
judicial
Could I
discretion.
just ask, Mike, the current position, does the judge not have a residual power to do that?
I'm unclear that there seem to be a number of avenues open to judges in terms of pre-trial mechanism. This is I think, a clearly stated route. Are you considering there's a different existing route?
No, I thought it might already exist, but whether it does or not, I suppose it does no harm to say in the legislation that it can be done.
Okay. Members have any other further questions about the amendment? Okay. Confirm we understand the amendment? Yes. Therefore, on the amendment, are members content that the new clause 10A, in line with the wording and table items, stands part of the bill?
Great.
Agreed?
Agreed.
Okay.
Agreed.
Lovely.
Okay. Clause 11, trial to be without a jury. This clause at page 51 removes the presumption in favour of a jury trial in defamation cases. Members, do we understand clause 11? Therefore, if members are content, is the committee therefore content that the clause as drafted stands part of the bill?
No.
Okay. Right. Therefore, those in favour of clause 11 raise their hands.
1, 2, 3. That's 3.
Okay. Those against clause 11 raise their hands.
1, 2, 3, 4. That's 4.
Okay. Abstentions? 2 abstentions.
Okay, that adds up, so that's it's negative.
So that's negative. Okay. Clause 12, power of court to order a summary of its judgment to be published. In summary disposal proceedings under Section 8 of the 1996 Act, the court has power to order an unsuccessful defendant to publish a summary of its judgment where the parties cannot agree the content of any correction or apology. The clause at page 54 gives the court power to order a summary of its judgment to be published in defamation proceedings more generally. Members, do we understand clause 12? Yes. Is the committee content that clause 12 stands part of the bill as drafted? Agreed. Clause 13, order to remove statement or cease distribution. This clause at page 55 relates to situations where an author may not always be in a position to remove or prevent further dissemination of material which has been found to be defamatory. Members, are we content we understand clause 13?
Mike, could you just outline what sort of circumstances you see this applying?
Well, for example, if I post something online and take it down, I can't stop people having screenshotted it and continuing to publish.
Oh, okay.
Happy with that, Jim? Okay. Therefore, is the committee content that clause 13 stands part of the bill as drafted?
Great.
Are we agreed?
Great.
Great. Okay. The bill sponsor has proposed an amendment which introduces a new clause 13 alpha, which would require the department to review the jurisdiction of the county court. This is shown in tabled items as Amendment 9. Members, have you any questions about this amendment? Okay. Are we content we understand the amendment?
Okay.
Okay. Therefore, is the committee content that the new clause 13 alpha, in line with the wording in tabled items, stands part of the bill? Are we agreed?
Okay.
Agreed. Clause 14, actions for slander, special damage. The clause at page 56 repeals the Slander of Women Act 1891 and overturns a common law rule relating to special damage. Members, do we understand clause 14?
Certainly do. I wonder how on earth that managed to stay in the statute books for so long.
Get rid of that one. Right. If members are therefore content that clause 14 as drafted stands part of the bill. Are we agreed? Agreed. Okay. The bill sponsor has proposed an amendment which would introduce a new clause 14 alpha, which would require the department to review the operation of the bill and related matters within 2 years of royal assent. This is Amendment 10. Mike, do you just want to talk to that for a moment?
Well, I'm conscious that the department thinks the time isn't right and has pointed to the fact that the Government of Ireland appear to be thinking of amending or updating their laws of defamation, and Scotland did last year, so that it is a fluid situation. So what I wanted to do was make provision where the department can continue to do what they say they're doing, which is basically scoping, for want of a better phrase. And it would also give an opportunity after 2 years to say, well, how has this bill actually worked out in practice? So you have those two kind of review streams ongoing, and it may be that after 2 years you say, well, there's something we've missed, or there has been a development, because I think this environment is changing all the time. I mean, if you look at what's happening in Dublin, they're reviewing laws which they only introduced in 2009, and by 2019 they're holding conferences reviewing what they've done. So the shelf life of defamation legislation, I would suggest, is measured in years rather than decades. So that's what that was intended to do, and to acknowledge concerns of this committee and of departmental officials.
Okay. Any other comments? Okay. The department suggested that the review be undertaken within 3 to 5 years of commencement rather than royal assent. This would ensure that the provisions have actually been commenced before they are reviewed. Do members have any views on this?
Just
go ahead, Matthew.
As the Mayor Chair, if I'm understanding correctly, the department's position is that they want a longer deadline to review, as it were, which would slightly, not that it just seems to marginally contradict the idea that they that this is stuff that will be out of date, or that's a fast-moving question. But I don't have particularly strong views. The only point I would make about the new clause generally is that it answers quite a lot of the department's practical concerns around this being not the right time, as it were.
So could I make a comment?
Go ahead, Jim.
I think you have to read this with clause 18, which is the commencement clause. Under the commencement clause, as it currently stands, it's in the discretion of the department when they'll start most of it.
Yeah.
They could sit on their hands, and in 2 years it might never have commenced. So how does the review fit in with that?
Chair, there is one further amendment which I have not found a form of words for, and it is for clause 18. And I very much take on board that I have potentially given too much discretion to the department in terms of commencement. And the reason I haven't brought forward an amendment yet is I just need a few more days to be sure. You wouldn't necessarily be commencing everything at the same time.
Right.
But I think I do need to amend clause 18 to ensure that
because
there are time limits placed on all the duties that will be placed on the department in terms of when they commence.
Okay.
And if I could just comment generally, I think that's something the Assembly should have a weather eye to in all legislation. There have been multiple instances where the Assembly has passed certain matters left the commencement to the departments, and they've never commenced.
Yeah.
Well, if I may, Chair, at the Economy Committee, we were looking at a private member's bill which had the very same issue in terms of commencement. So we've gone back to the bill's sponsor to ask why they were leaving such discretion to the department, or whether they might consider putting a time limit.
Yeah.
Okay.
Yeah, just Dim's point is valid. You know, the commencement and review, obviously, if you're going to come forward, Mike, with an amendment on commencement timing, obviously this amendment in front of us might be slightly different in regards to its timing. 2 years might be the right figure, it could be 3, could be 4.
Yeah.
Oh, is received royal assent, or is it commencement?
From royal assent at presently, yeah.
Royal assent.
As there may well be different commencement dates for different provisions.
Yeah.
I think royal assent is the preferred option.
Okay. So therefore, because we need to move on, is the committee therefore content that the new clause 14 alpha, in line with the wording in the tabled item, stands part of the bill? Are we agreed? Agreed. Okay. Clause 15, meaning of publish and statement. The clause at page 57 sets out definitions of the term publish, publication and statement for the purposes of the Act. Members, do we understand page 15? The bill sponsor has proposed typographical amendments, amendments 11 and 12 in the tabled items. Do we have any questions about the amendments? Are we content to amend clause 15 in line with the wording in tabled items in respect to amendments 11 and 12? Are we content? Agreed. Therefore, the members is therefore content that clause 15 as amended stands part of the bill. Are we agreed? Agreed. Clause 16, consequential amendments and savings, etc. Subsections 1 to 3 make consequential amendments to reflect the new defences of truth and honest opinion. Members, do we understand clause 16? Yep. Bill sponsor has proposed typographical amendments, amendment 13 in tabled items. Do we have any questions about the amendments? No. Therefore, are members content to amend clause 16 in line with the wording in the tabled items? Is this agreed? Agreed. Agreed. Therefore, are members content that clause 16 as amended stands part of the bill? Is this agreed? Agreed. Clause 17, regulation and orders. The clause also has at page 57 makes provision on the making of regulation and orders under the Act. As drafted, these will be subject to negative resolution. Members, are we understand clause 17? Okay. Bill sponsor has proposed amendment 14, which makes all regulations subject to the draft affirmative resolution.
Actually, Chairperson, I tried to get those switched off and I can't. It's amendment 14 and 15, which refer to the draft affirmative resolution. I've made an error in your brief.
So 14 and 15?
Yeah.
Okay, thank you. Members, do we have any questions about the amendment? Okay. Are members content to amend clause 17 in line with the wording in the tabled items? Is this agreed? Agreed. Therefore, is the committee content that clause 17 as amended stands part of the bill? Is this agreed? Okay. Agreed. Clause 18, commencement. As drafted, the bill will largely come into operation on such days or days as the Department of Finance will appoint by order. I think we understood that from the discussion we've just had. Mike, you're proposing an amendment. You've also done with a typographical error, which is amendment 15. We'll talk about
16. Sorry.
16. Sorry, my I'll be in. Sorry, I'll allude to it as well. But you also said that you're bringing forward the.
There will be an amendment in terms of commencements. Yes.
Okay. Okay. So therefore, the amendment. This is I'm dealing purely with a typographical amendment at 16. Therefore, members, are we content to amend clause 18 in line with the wording in the tabled items? Is this agreed? Agreed. Okay. And the committee has also formally agreed to consider further amendments which would ensure the commencement occurred after a reasonable time period, not at the discretion of the department. This has not been tabled. You've already explained that to us, Mike, as well. So bearing in mind we're expecting that to come through, therefore is the committee therefore content that clause 18 with the recommended amendment as it is stands part of the bill, bearing in mind we're likely to get the further amendment.
Chair, just to clarify, in terms of commencement, do members have a preference maybe to help the bill sponsor in terms of when it should be commenced? Should it be commenced at royal assent? Is that what members are saying, Chairperson?
I'll go through the bill. So, royal assent?
Yes.
Didn't even move your lips.
Yes, but I do want to take a bit more advice in terms of should there be different commencement dates for different duties within this bill, Chair?
I must say I think that's wise. I think there are issues which are relatively straightforward. There's others which are bit more complex.
So there would be some that I would want to commence either on the day or the day after royal assent. But there may be others that you might want to give the department appropriate time to get around.
Without saying what your amendment would say, but sort of the bill would commence at royal assent with the exception of clauses, whatever happens to be, whatever particular ones.
Yeah, I mean, at the moment I've got Section 15, subsections 4.8 of Section 16 or the day after royal assent. The others are up to the department. So it's going to be much more detailed in terms of clause by clause.
Okay.
So some will come in at royal assent and some will need time so the department can draw up the regulations.
Shouldn't be to really, as clause 18's changed.
So we shouldn't, but is the...
Yeah. Committee, just to take your views on this, we've heard from the bill sponsor, and I think we're all agreed that the more nuanced commencement with both royal assent and other options with it should be considered. I don't think we should be putting clause 18, therefore, to our consideration at this stage until we've actually seen that. If we are agreed.
Oh,
Unless the person of the committee wants to
Well,
tell the clerk to go away and come up with their own amendment, I could do that just as easily and come back next week with an amendment to clause 18. Or we could wait for the bill sponsor.
well, what's the bill sponsor's
What's your
timings?
I would like to think I'll have it done in days.
Okay.
Next week.
Next week.
Okay, so we can not consider that.
Not consider it and do clause 18. Okay. Clause 19 sets out the short title of the Defamation Act, Northern Ireland 2021. Members, do we understand clause 19?
Chair, I think maybe on those, if we're going to follow the rules appropriately, then we won't actually conclude formal clause by clause today. What we may do, if the committee agrees, is do this next week and then immediately do the report. So I will guess at what I think the committee is going to go for, and that we can do all of these things next week. The committee are agreeable, it won't take long.
Yeah, because what we're left now was clause 19,
Easy.
which is the short title.
Yeah.
Are we content with that, committee? Okay. Agreed. Thank you very much indeed. Mike, thanks very much indeed for coming in.
Thank you,
and,
Chair.
Look forward to that as well. And again, so for next week, Peter, we'll do the final clause 18, clause 19. That will be the final report, but we'll also, or sorry, that will be the formal clause by clause, and then we also do the final report.
So I will bring so I'll have a go at what I think members are going to go with. And if you want to change that next week, if it turns out differently, that's okay. We should put away clause by clause next week and agree the report as well, if members are content, and that is 2 days before we're due to report.
Okay, if that's agreed. Good. Okay, thank you very much indeed. Thanks, Mike.
Thank you.
Let's crack on with the LCMs,
Okay.
and then we'll come back for
Yep.
1500. Team, bearing in mind we're sort of trying to keep ourselves a sort of head of where we need to go to. Can we go to item 8 on the agenda, which is subordinate legislation, hospitality support? And I want to do that in subordinate legislation, making levelling differing rates, to look at that issue as items 8 and 9 on the agenda, if we're happy to do so. Agreed. Item number 8 on the agenda, hospitality support. Members asked to note on page 435 a written briefing on Statutory Rule 5, 2022, Financial Assistance Coronavirus Hospitality Regulations Northern Ireland 2022. The Department has made a statutory rule to make provision for payment of 40 million in one-off grants to the hospitality sector following COVID restrictions and loss of footfall over the Christmas period. LPS will make the payments using the LRSS data sets to restaurants, cafes, coffee shops, public houses, social clubs and private members clubs, but not sporting clubhouses. It appears that no additional application is required. There appears to be 3 tranches of support with grants at 10,000, 15,000 and 20,000. On page 35 of tabled items, the committee is asked to note a response to related committee queries. The rule is subject to negative resolution procedure and is led in breach of the 21-day rule. The rule came into effect on the 17th of January. Any comments, Jim? You want to?
Well, I know I feel a bit retrospective approval, but in this case, principles are totally acceptable. I take it the department have gone ahead and done all the preparation in advance of this. You know, I think it's desperately needed. It's a very blunt instrument done on rateable value, but there's no other way of getting money out to the needy hospitality sector in any other way. So yes, I'm very keen on this.
Okay, Keith.
Yeah, just a query. It's referred in there that it's under LRSS or a business that got LRSS. What about a new business, Chair? That's just maybe I've missed it. But what happens if a new business is opened, which is now ultimately closed, or what support will they get?
I think they can make an application, Chairperson, and would be I think they can make an application. It would be the same criteria.
But
So
we'll write just a clarification to make sure we've got that.
That's fine.
But I think saying that, I don't think I don't get a sense from the committee we want to slow this process up.
No, but it's just a issue.
Okay, and therefore, in that case, if members are therefore content, I say the Committee for Finance has considered Statutory Rule 5/2022, the Financial Assistance Coronavirus Hospitality Regulations Northern Ireland 2022, and subject to the report of the examiner's statutory rules, has no objections to the rule. Is this agreed? Agreed. Okay. Item agenda number 9, subordinate legislation making levying different rates. In January 2021, the Department brought forward the Rates, Making and Levying of Different Rates Regulations Northern Ireland 2021. These were designed to permit increased flexibility in setting domestic and non-domestic rates by the removal of mandatory prescribed conversion factors that were used for rate setting. The proposed rule would allow the inclusion of the conversion factors table on a non-mandatory basis, which would allow the legislation to be referenced in the annual calculation of the rate support grant made by the Department for Communities. The Department of Finance has no policy role in relation to that grant. The request for the rule came in from a district council. The proposed rule will be subject to negative resolution procedures. Members, any comments? I think last year, around about this time last year, we considered we did consider the issue of sort of conversion factors, and I think we had a fairly comprehensive briefing at the time about conversion factors, and I don't have any issues unless any other member has. Okay, therefore, is the committee therefore content with the policy objectives of the proposed rule, and is therefore content for the department to make this rule? Is this agreed? Agreed. We'll not do the LCM, we'll move into correspondence. If we're happy, team, I'll move on to item number 11 in the agenda, correspondence. We'll do the public sector pensions after we've done the Fiscal Commission, if we're content. Agreed. Members asked to note the index of 11 received items of correspondence at page 487. The committee is asked to note at page 489 an interim response from the Committee for Agriculture on the 22-25 draft budget. Is the committee content to note the correspondence? Great. Education budget. The committee is asked to note at page 492 a copy of a response from the Minister of Finance to the Committee for Education, disputing the suggestion that the 22-25 draft budget would lead to a 2% real terms reduction in the Department of Education budget. Is the committee content to note this correspondence? Noted. Unique circumstances funding. The committee is asked to note at page 496 a response from the Department of Finance, again declining to provide information on the unique circumstances funding. Are we content to note this?
No. That's a bit odd. That doesn't often happen. Do we not have powers to force them to produce this?
You do. I think, but the argument, as you can look at the correspondence, there's a debate between the Department of Finance and the Northern Ireland Office over who has this information. So Northern Ireland Office, I think, has the information, but has declined to give it to the committee previously. I know the Committee for the Executive Office have asked the same questions. We've also written to TEO about this, so we keep going round and round the circle where the Department of Finance, TEO, Northern Ireland Office all refuse to provide information. They appear to indicate the agreement was with parties, some political parties, about how that money would be spent, and they have declined to provide us with that information.
Go ahead, Matthew.
The statement that the unique circumstances funding is provided by the Treasury is allocated and controlled by the NIO. Allocated meaning it's agreed politically, as in, for example, the Confidence and Supply money or the Fresh Start money. So it's agreed politically by the NIO, the UK government, sometimes up to and including the Prime Minister and the Taoiseach, if that's what's happened. But the money isn't dispersed by them. Unique circumstances money shows up in the budget documents, which are published by the Department of Finance.
No,
That's correct, isn't it?
I don't believe it is. I don't think this is departmental spending. I think the allocation is made by NIO to the various groups for the various reasons that were agreed in NDNA. So I don't believe it appears in departmental spending, though there were bids made by departments.
So, but unique circumstances funding. So, are we saying unique circumstances funding doesn't? That the Department of Finance has no role in dispersing that money. Indeed, that it's.
I think that's what they're saying. It is that it sits with the NIO.
No, but
They say allocate. That letter says that the money is allocated by the NIO. So that's true in the sense that the Department of Finance has a role in allocating, for example, the 2022-25 budget that we've just been discussing. We'll discuss again, but they don't have a role. So the Department of Finance didn't agree what was in the confidence and supply, but they presumably have some role in the actual process of dispersing it. It would seem odd that they don't, given its.
Chair, the letter saying that they have no role in the allocation or dispersion of the money.
But have they a role in
distribution?
I think committee, though, but the issue is that there is only one avenue for the disbursement of monies through the Northern Ireland government, and that is through the Department of Finance.
Chair, could I ask, what's our understanding in terms of bidding for this money? Do departments bid for any of this money?
Departments did bid for this money. The committee.
Well, surely then we're at least entitled to know what bids they made.
I think the committee wrote seeking these bids, and we didn't get. I think we got some answers. I think the Department for Communities. We got some information about that. So this has been a long-running correspondence for not quite a year.
It seems to be in Congress that the departments could say, we bid, and they bid because they're going to spend and allocate, and then not tell us what the outcome is.
Sorry, Chair. Sorry to interrupt you in there, but
go ahead.
I mean, with respect to what just said that the letter said that they don't have a role in allocation or dispersal, it doesn't actually. The dispersal was the word I used. I don't see that word in the letter. Certainly, the letter signed off by the DALO at 496, and if I'm just looking at the budget, the 22-25 draft budget, which has on page 21 a table financial relating to capital DEL, which includes it includes Fresh Start and Stratum and things like that, which are, I think, what we're talking about, isn't it?
Yeah.
Just for clarity, I mean, the letter I was reading at that particular time was on page 498. I think it's from the Executive Office, and it says the allocations and distribution of this funding is solely a matter for the NIO.
Fair enough, but it does appear, but there's a table for the. And just for the Department of Finance, say they have no role in that. But I mean, it's in a table in the budget document, so it seems a bit odd for them to say they've no role in it.
Yeah.
Yeah, it's in the budget document, surely. Yeah. They're answerable for it.
Is it in the budget document?
Let's do some.
Where's that in the budget document?
Before we maybe Matthew can have a look at it separately, but maybe we can ask just after the team here to have a look at it to see if it is in the budget document, and then.
Well, Matthew gave us chapter and verse, did he not?
Well, this is I printed out of the draft budget document, page 21 of the draft budget document. I mean, this is only one page I happen to be able to open. Financial packages summary, and then it does say following sets out a summary of the British government financial packages amount, and it talks about financial packages capital DEL, and then has a table. The point I'm making is, if it's nothing to do with the Department of Finance, then it wouldn't appear at all in the Department of Finance document.
Matthew, let's do some further research on it. Look, Tim, let's do some further research on it, and we'll bring this back again next week to have a look at.
Are we not dancing on the head of a pin here? No matter who gives the money or who distributes it, it obviously has some implications for the finances of services in Northern Ireland.
Yeah.
Can we, as a committee, not simply ask for that, no matter who's in charge, and what is the purpose of hiding it? Why are they so reluctant? Just let us have it.
I think the committee has asked Northern Ireland Office several times,
Yes,
and
why
they've
are the
declined.
NIO so shy about telling anybody?
I don't know, they have not indicated. So, I'll take that away and
I will
come
take
back
that away
and
too.
see if it appears in the budget document.
The other point is that appearing in the budget process, it is part of the public finances of Northern Ireland. And part of the duty and responsibility of this committee is to look at the public finances of Northern Ireland. So if there is a different funding line that is coming in, but the disbursement to other government departments is through the Department of Finance. They don't, the NIO just don't write a cheque and hand it to the PUS of whichever particular department. That's not how it works.
I think they hand out checks to people who aren't in the department, so they're handing out directly to organisations, so it never goes through the departments.
Yeah, but then it wouldn't appear in the budget.
Anyway, there you go.
Oh, there we go. Okay. Well, that's a bit of a conundrum. Right. Okay, next item, Procurement Reform Bill. The committee is asked to note on page 504 an update from the Department of Finance on the Westminster Procurement Reform Bill. The Executive has agreed for provisions to be made in the bill in some regards respect of Northern Ireland. It is understood that an LCM will not come forward until the next mandate. The relevant provisions include local powers relating to issuing recommendations to contracting authorities. Members, are we content to note this correspondence? Content. And I think we get one more item of correspondence before we move to the Fiscal Commission. RHI closure delay. The committee is asked to note on page 507 a response from the Department of Finance to the committee's query, which appears to indicate that although the RHI closure fund is not to be used in this mandate, the department hasn't yet asked Treasury if the funding can be rolled over to the next financial year. I believe this is £91 million, if I'm correct on this one. Are we content to write to the department again in this regard? Because I think the presumption that the Treasury will roll over 91 million, I think, is quite a large one. I would like to actually see that something in writing from the Treasury that said they were willing to do so. Are we content? Okay, agreed. Okay, I don't think we might even get...
Could I just quickly revert to the subject of the unique circumstances? I was just looking, there was a assembly question, and the clerk might like to explore this. It's 24,801, 24801, to the Minister of Health, who talked about unique circumstances funding for the Londonderry Addiction Centre.
Mm-hmm.
So some departments have some knowledge.
Yeah. They do, but there's a list in the NGNA document which sets out addiction services as one of them. There's something about mental health or other things. So the committee is aware of that. But anyway, I will follow up on that question and return.
Mm-hmm.
I think the gang's all here, Chair.
Mm-hmm. Okay. Energy Payment Support Scheme. The committee is asked to note on page 512 a written statement from the Minister of Finance in respect of the Department for Communities £200 per household energy support payment scheme costing 55 million. Further details to be provided by January monitoring. Are we content to note this correspondence?
Yes, Mr. Chairman, and that's a sensible way to do it. Meanwhile, with the utter chaos of the smaller scheme, the Bryson House scheme, why they simply didn't add the Bryson House money to these allocations and just, okay, it might only be an extra 40 or 50 pounds per person, but that would have been much simpler than the chaotic situation where we have at the moment, where it's a lottery as to whether you can get on and get your considered.
Yep.
Probably not the direct remit of this committee, but certainly the £200 will be simple, efficient, and get to the people who need it. The Bryson House money is, you might as well fill in 6 numbers on a Saturday night.
Okay. Okay, team, we'll come back to the next item of correspondence will be 11.8, which is the housing benefit transfer. If we now move back through our agenda, we got to item 7, which is the Fiscal Commission, oral evidence from the Fiscal Commission, their interim report. I think we're just about on to... We are, indeed. Can I welcome sort of Paul Johnson, Ian McLean, Cathy and Lisa, if you're up and about?
Lisa's not.
Lisa's not attending, okay.
Hello.
Okay. Paul, Ian, Cathy, can you hear us okay?
I just about in that case. Right up till then, I could hear you fine.
Okay.
Can you hear him okay? Can you understand this?
I can hear Paul. Ian, can we hear you?
Test message. Can I hear you? Can you hear me?
Yes, we can now indeed. Sorry. Kathy?
One test from me too. I can hear everything fine.
Yeah. I apologise if you keep on hearing the division bell going off in the background. We're in the midst of, I can't remember which clause we're up to in the Integrated Education Bill, but I think we're about 3/4 of the way through. So sort of apologies if you hear that bell coming through. Team, this is receive oral evidence from the Fiscal Commission for Northern Ireland on its interim report. The session will be reported by Hansard. May I thank Sir Professor Johnson for meeting with me informally earlier on in the week, and sort of because I've asked a lot of questions directly to him, I'll give the committee more chance to sort of ask directly, and sort of I'll keep my sort of questioning to the minimum. I'll keep Melissa quite happy. I'm sure it will, as always. Clerk's briefing notes, page 164. The Fiscal Commission report is on page 172. Correspondence from the copies of correspondence from the Treasury and Ministry is page 68 and page 32 of the tabled items. The European Scrutiny Committee correspondence in respect of EU rules of VAT is page 415, and a copy of today's presentation is at page 12 of the tabled items. Team, you're very welcome to the Committee for Finance. We've invited you to the meeting to provide members with an oral briefing on your interim report. More fiscal devolution for Northern Ireland? Question mark. Okay. Can I ask, Paul, can I ask you to make your opening presentation, please?
Sure. Inevitably, I can't now see what I need to share.
We've all got copies of the presentation in front of us, Paul, so if you want to talk through them, that's fine.
I'm slightly baffled as to why this worked earlier and now it doesn't. This is a new piece of technology on me. Okay.
So it's page 12 of tabled items for members.
I simply can't see. Simply not there. Hang on. Too many things open, I think, is the problem.
Oh, that's looking good. Yep.
Sorry, I'm going to have to do without. For whatever reason, the technology has baffled me.
No, it's just come up on our screens, Paul.
Okay, let me. This is not quite the view that I was intending, but hopefully that will do. Right. Okay. Let me power on through. I've got a few slides to get through. Hopefully that has moved down. Yes. So just to remind of the our remit, which was essentially just to look at the case for increasing fiscal powers and advise the Finance Minister. We were established by Conor Murphy, and we are to report before the elections in May. Particular thank you as I do this to Kathy, Ian and Lisa, who have done so much work with us, and also to Aidan McMahon and the Secretariat, who have done a huge amount. So what are we doing? Well, we're reporting in two stages. What you've got is our interim report, which is actually the bulk of our work. We've only got a few weeks now to add to that. As you'll see in there, we've got a lot of the context for Northern Ireland economy, our view about what's needed for fiscal devolution, and an assessment of individual taxes. And we've got a short list of those we think it's worth looking at further, which I'll come on to. We're going to add to that report rather than do an entirely new one, and what we're looking at over these few weeks is particularly operational aspects of implementation, some significant work on block grant adjustments, which will have to come, in our view, with any change to the fiscal settlement, and also we're continuing our stakeholder engagement. Let me start on that. Actually, a rather important part of what we've done has been talking to more than 50 organisations and individuals over the last 9 months, including from all of the main political parties. And I guess I think it's worth just reflecting on some of the key messages we've got from them. I think a really important one from our point of view is that top one, need for public engagement and education. I think almost everyone we spoke to felt there was a job to do in Northern Ireland to increase people's understanding and engagement of the fiscal situation and of how the tax and spending system worked. And we hope to play a role in doing something about that. Clearly, it's important in all of this, as we may discuss later, that there's mutual confidence and engagement between Northern Ireland and the UK. We were told very clearly, and we certainly agreed with this. This is not something we needed telling, that this should be about both. This should be symmetric. This is about increasing or decreasing taxes, not by any means just about increasing them. Some concerns were expressed about economic and administrative capacity, and also by pretty much everyone we spoke to. Concerns were expressed about the political and institutional capacity to take on devolution. So all of those, I think, is worth reflecting on, because I think it's fair to say that pretty much a large majority of the stakeholders we spoke to brought up all of those issues. Now, in terms of context, I'm sure you're familiar with this sort of set of facts, which is essentially that Northern Ireland is one of the weakest performing regions of the UK in terms of its economy, whether you measure that by employment, earnings, productivity, economic inactivity, or GDP per head. And not only is it one of the weakest, it is one of the weakest over the long run. So that's an important part of context. A second important part for us is that whilst in the sense we're the Fiscal Commission, and fiscal covers tax and spending, it's already the case, of course, that the executive controls virtually all of the spending that takes place within Northern Ireland, with the exception of social security, which, whilst evolved, is very limited in practice. And nearly all of that budget comes from the block grant. Really, the only tax resource is for rates. That's about £1.20 of the tax revenue that the NI executive spends. Next really important piece of context here is that spending in Northern Ireland on services is a lot higher than it is across the UK as a whole. That said, it is not particularly high given the level of income in Northern Ireland. It's pretty much in line with what you might expect for a region elsewhere in the UK. But you can see that's the green bit there. It's 21% higher than the UK average. You can see that for some particularly smaller spending streams, it's much, much higher. Education a bit higher, health only a little bit higher. And you can see there science and technology, interestingly enough, is much lower than across the rest of the UK. So lots of choices available, even now, clearly to the government. To give a sense of where tax currently comes from, tax per head in Northern Ireland is about 20% lower than it is in the UK as a whole, largely reflecting that light blue block there, which is income tax, much less income tax per person in Northern Ireland, reflecting again those low levels of income, and in particular, very small numbers of very high income people. Income tax, of course, being a very redistributive and progressive tax. So high levels of spending and low levels of tax. Not surprisingly, that gives you a big notional fiscal deficit. But really important from our point of view, that's irrelevant really to the question of whether some tax powers can be devolved, because you'd simply adjust the current block grant in response to that. Clearly, it would make Northern Ireland, as it were, going it alone, extremely challenging. So the last real bit of context here is what I have learned to call super parity. It's important, I think, to put in the context here that if the intention of tax devolution is to raise additional revenue, there are already plenty of options where that would be possible in a world in which Northern Ireland had policies more like those in England in particular. So obviously the big ones are around water charges and tuition fees, but also some of the welfare mitigations and domiciliary care charges. These add up to a big number, 600 to 700 million a year, which in the UK context, which is the context I'm used to thinking about, that's a £20 billion capacity for additional revenue, which is equivalent to a couple of pence at least on the main rates of income tax. So if the overriding priority is raising more funds, then options are there. Really important part of thinking about tax devolution, and something we will look at in a lot more detail over the next few weeks, is what then happens to the block grant, which currently funds pretty much all spending in Northern Ireland. Clearly, if a tax is devolved to Northern Ireland, then the block grant will need adjusting, and that's actually very far from straightforward. In a sense, it's easy to see how much you might adjust it in year one, depending on the tax that is devolved. How that changes over time is a matter of considerable. There are very different ways of doing this, and something I think is important to point out is that we have significant experience of this in the Scottish context. Clearly, income tax is devolved to Scotland, or a significant part of it is, because incomes in Scotland have risen less quickly than in the rest of the UK. A consequence of this has been a quite significant loss of revenue to Scotland, because the block grant has been adjusted, taking account of that lower rate of increase in income in Scotland. So there are risks and benefits from devolution. Scotland, as it happens, has been on the wrong end of some of those risks over the last few years. Clearly, had the economy done better than that in the rest of the UK, then they would have been, they would have had they would have had more money to play with. And I think if any part of the UK going down the devolution route needs to understand that there are risks as well as benefits. But in a little bit more detail, each of Scotland and Wales have been on a much longer journey to fiscal devolution. They've had, as it were, they each had two commissions, a sort of an initial, more technical one, I think rather like the one that we are running at the moment, the Holtham Commission in Wales, for example, and then a more political one a few years later, and then change a few years after that. So I think we see ourselves as, if there is to be a journey towards devolution, then we are the kicking off point, as it were, rather than in any sense the end point. So when it comes to thinking about taxes, obviously there are a lot of things you need to think about in terms of what is suitable for devolution. Are there legal constraints? That's clearly changed over time. The economic and political context, efficiency, accountability, and so on. So we've been thinking about all of these things as we've looked at individual taxes. Where have we got? Well, I mean, the truth is that from a purely technocratic point of view, in the long term across the UK, there's nothing fundamental that stops quite a significant fraction of current taxes from being devolved. That said, you certainly wouldn't want to do a huge amount all in one go. Scotland and Wales have taken on relatively limited tax powers initially, and that partly reflects testing capacity in terms of administration. It also reflects the risks that will be associated with doing more very quickly. So if we're going to go down this route, then there's certainly, we don't think more than one of the big taxes should be devolved. The big ones being income tax, national insurance and VAT. They raise about 2/3 of revenue. And there may well be a case simply for saying, let's look at some of the smaller taxes in the first instance. So where did we come out? Well, there's an awful lot of taxes out there, actually. We looked at more than 20 individual taxes, and you'll see in the report we've gone into most of those in quite a substantial amount of detail. And you'll see here the 7 that we think it's worth us looking at further, which we're looking at over the coming weeks. Much the biggest one is income tax. We know from experience in Scotland and Wales that some limited devolution of income tax is feasible administratively. As I've described, there are also risks associated with that. We certainly don't think that there will be scope for looking at VAT or national insurance at the same time. And the apprenticeship levy we put on there for 2 reasons. First, it's closely linked to the income tax base, and secondly, it's clearly closely linked to a devolved policy on training. And indeed, some of these other ones we've got here, fuel duty, alcohol duties in particular, are very closely related to other devolved policies, in particular for alcohol and tobacco, devolved health responsibility. And Northern Ireland, it will be easier to devolve these taxes because of no land border with the rest of the UK, and it may be more appropriate to devolve to Northern Ireland because they possibly need to be set in cognizance of what's happening in the Republic. Stamp duty, land tax is devolved in Scotland and successfully so. Obviously, houses don't move, so this is something that it's if you're going to devolve anything at a local area, that is a relatively obvious one to do that. We looked in quite some detail at corporation tax. There are a lot of different issues around there. This is particularly related to the economic performance of Northern Ireland, and particularly related to the low rates in the Republic. There is certainly some evidence that it could be a strong economic lever, but there are a lot of technical and political complexities about it. There would only be a value in devolving corporation tax if one were to assume that the Northern Ireland Executive were going to cut it significantly. There would then need to be a really substantial negotiation over the block grant, because the upfront cost of doing that would be very significant, with the hope, but by no means the certainty, that would result in higher economic growth and higher tax revenues in the longer run. So our view on this is that it's not really for us to say, yes, this is something that the Northern Ireland Executive should try and get devolution on. But if they do, they need to do a series of things which I think over and above what would be the case elsewhere. In particular, explain how the powers will be used, reach agreement in collaboration with the Treasury over adjustment of the block grant, which is certainly one of the things which led to previous moves in this direction not occurring, and methods for agreeing how effects on other revenues, and so on and so on. This is significantly, in our view, more complex, particularly in terms of the relationship with the rest of the UK, than other taxes. That's not to say there's no case for devolution, but and indeed in some respects there's a strong case for devolution. It's a much more complex issue than for some of the other taxes. There's a whole host of other taxes we looked at. You see the list here. And as I said up front, from a technical point of view, from an in-principle point of view, there's quite a lot that it would not be beyond the bounds of possibility within a state to, and this is not specific to Northern Ireland really in any sense, it would not be impossible or daft to think about devolving in the long run. But those, for various reasons, there's more complexity with all of those than there would be with the ones that we're looking at further. And then there are some where it really would be very difficult to make changes. So that very, very quickly is a run through what, as you can see, is a very substantial report. And I hope also Kathy and Ian be very happy to take any questions on that.
Okay. Paul, thank you very much indeed, and thank you very much indeed for your briefing. And just for all those out there who are actually out there watching our committee, you can see that my own example has already been well tabbed up with lots of questions and answers. But thank you for answering them earlier on in the week. So I'll pass it over to the committee. Jim, you're up first.
Okay, thank you very much. Could I commend you for your report? I thought it was very informative and obviously very well researched. And I think it's an area where there has been a dearth of informed opinion expressed. And to me, having read and listened to some of the more fantastical suggestions of devolution of tax powers, I thought it was quite a reality check. Reality check in a number of ways. It very directly addresses the fiscal deficit. Is clear that the fiscal deficit is of that order of 10 billion, and that it does include, as it should, our share of the non-identifiable expenditure, which must have come as a surprise to our finance minister, because he's on record to this committee and in the House in disputing the 10 billion deficit and trying to dress it up in other ways to pretend it doesn't really exist. I think your report explodes that myth very successfully. It also deals with the reality that there could be particular downsides, and the example of Scotland is a sobering example. So, given the block grant situation and the fact that there has to be a knock-on effect on the block grant from the devolving of tax-raising powers, why would an assembly such as this therefore see much, if any, attraction in devolving fiscal powers? And that's not to deal with the dysfunctionalism that is writ large over this place, but just on the sheer balancing of the books exercise. Why would any devolved assembly such as this want to go down that road?
Well, that's a very big question, and I'm sure that Kathy and Ian would like to come in behind me. But, I mean, there are a set of in-principle reasons for thinking that tax devolution might be appropriate. The first is obviously to do with accountability to the local electorate in a world in which, particularly in a world in which you're responsible for all of the spending. I think this is not a comment particularly on Northern Ireland, but from a Westminster perspective, it is easy for devolved governments to say that we need some more. Always to say we need some more money. It's the fault of Westminster for not funding us appropriately, and therefore, as it were, escape from a degree of accountability. There's clearly issues around supporting other policies, as I was suggesting. So the Assembly is responsible for public health in Northern Ireland, but has no control over alcohol and tobacco taxation, for example. And then there are particularities about how you might want to support the economy, where you might think it's appropriate to have a different rate of corporation tax, for example, if you're willing to fund and prioritise that. So there are numerous reasons, I think, in principle, for thinking that devolution of tax powers to lower than a UK level might be attractive. But as you say, that needs to be very much balanced off against the fact that there are clearly administrative and practical issues there. And very importantly, there are substantive risks associated with that. Now, there are risks on both sides. If the Northern Ireland economy were to grow more quickly than that in the UK, the rest of the UK, following devolution, then Northern Ireland would reap benefits. But the volatility and risk undoubtedly is there. Ian or Kathy, do you want to come in on that? Because that feels to me like the fundamental question in some sense.
Sure, yeah, I'll come in on that. Well, I think one of the key things is also that the Northern Ireland Executive and Assembly and Northern Ireland citizens might have different preferences when it comes to things like the redistribution of taxes, which is what you've seen in Scotland and Wales in relation to income tax and the bans that are in place there. So that's another reason. But primarily, it probably is around that accountability piece. When you talk to citizens about tax and spend policy, the idea that those decisions are taken somewhere else and that Northern Ireland only has the responsibility for the spend and not the tax raising side of things is something that a lot of people don't quite understand. And so to have devolution of some taxes does increase that accountability between the electorate and its elected officials.
Yes, but the Treasurer has been quite clear that if there's been any further fiscal devolution, it can only be on a basis of a sustainable footing. And we have recent correspondence from the Treasury indicating quite rightly that does not prevail. So is it not a bit of a pipe dream for those who want to see this, who are in fact contributors to the fact that we don't have a sustainable footing in our finances? How do we get to a sustainable footing? And isn't it right to say that has to be a common sense prerequisite before you start tinkering with anything?
I think that's right. I think you need to start from, not least the position of trust between the government in Whitehall and the government in Belfast. And my presumption, at least, is that the combination of the putting together of the Fiscal Council with some of the things that we're talking about in this report could be the first step towards the executive taking steps in that direction, such that they can persuade Whitehall of that sustainability. But of course, you're right. You need that level of governance, you need that level of sustainability, and you need that level of certainty that you can put in place the capacity to make all of this possible. So there are certain things that are needed in order for devolution to work, but it's certainly our view that those are not, those are a long way from being impossible in Northern Ireland, even if they're not fully met right now.
Thanks for now.
Okay, thanks, Jim. Matthew?
Thank you. Thank you, Paul and Kathy and Ian, for the report. It's extremely useful, and a huge amount of work has clearly gone into it. And I think it's going to be really this and the final report will be, I think, hopefully milestones for some time to come in terms of the debate around fiscal powers, but also more broadly governance here, because I think the question of fiscal devolution is kind of inseparable from the performance of our devolved institutions. I just want to and thank you for today's presentation, which has been a really pithy oversight. I just want to go back to something that was, I think, in the presentation and a point you made, Paul, which is clearly there is a fiscal deficit between Northern Ireland and the Exchequer. I don't think anyone would deny that. But you made the point that a net fiscal deficit with an Exchequer, whether it's Northern Ireland or anywhere else, is not necessarily not by definition an argument against fiscal devolution. Is it an argument perhaps for fiscal devolution, or is it or for targeted fiscal devolution, or is it simply are the two not related? If the question is clear.
I think on the whole, they're not necessarily related. I mean, it depends really on how the block grant adjustment works. I mean, Scotland has a very large fiscal deficit relative to the rest of the UK, and that really doesn't impinge at all on the arguments, I think, for the devolution of tax powers that have been devolved to Scotland. It's interesting, I hadn't thought about it, if I'm honest, in the other direction. I mean, supposing we were talking about devolution to London, which does have a very large fiscal surplus, I think, again, it would depend entirely on how the how the grant was adjusted. So, I mean, could you make a large fiscal deficit an argument for devolution? Well, given to the extent that that deficit arises from weak economic performance, then you might argue that having more fiscal powers could put more power in the local hands to improve that economic performance. But on the whole, I think the existence of the deficit is almost neither here nor there if we're thinking about devolving a tranche of income tax or stamp duty land tax, for example.
And Matthew, it's probably also important to note that most regions of the UK operate a notional fiscal deficit, so it's not that we are out of kilter or an anomaly. Paul's slide showed that there are only 3 parts of the UK that are don't operate on a notional fiscal deficit.
Yeah.
And just to go back, the relationship between that fiscal deficit and the concept of financial sustainability, which Jim had mentioned earlier as well. Connecting those two things together would require a more in-depth discussion between HM Treasury and the Northern Ireland Executive on what that means, what financial sustainability actually looks like in practical terms, and the methodology that would be used to decide upon that. Because if you take the fiscal deficit as an example, all of the disagreements that there have been in the past as to whether or not you calculate the fiscal balance in terms of total managed expenditure or identifiable spend and non-identifiable spend is the same when you make the arguments about, well, what does financial sustainability actually look like? What's the magic or the Treasury are looking for? And I don't think that the Executive have clarity on that.
So is the point you're making then that the question, if you're asserting, that the fiscal deficit be calculated including unidentifiable UK-wide spending, then in a sense the question of fiscal sustainability, financial sustainability for an executive is not completely a red herring, but slightly it's difficult. It's difficult to on the one hand argue that you control the calculation for the fiscal deficit, but at the same time you want to use a different measure, as it were, for executive sustainability. Is that what am I misunderstanding?
No, I suppose my point is they're inextricably linked in some ways, even though we discuss them quite separately. Okay,
and on the points about I agree that there's a huge thing to be done in terms of building, I think, public and confidence in us as institutions and as the executive in terms of its ability to use theoretical extra powers. But I just wanted to ask about the question of what's happened so far. So there have been, my party in principle supports greater fiscal devolution. We think and this report is clearly a useful contribution to that, but it has to be done on the basis of public confidence and rigor. Did you look at some of the examples already, including, one of the taxes that was mentioned was air passenger duty. There is a current bit of air passenger duty that's devolved to Northern Ireland, and it involves an annual block grant adjustment for theoretical long-haul flights, which don't exist at the minute and are unlikely to exist in the foreseeable future. Presumably that's an example of a bad piece of fiscal devolution, in part because it's done well. I'll let you. Did you look at that, and what conclusions did you draw from that?
Yes. We did indeed look at that. There was clearly a very specific reason for that piece of fiscal devolution, the attempt to keep the long-haul flight to the United States by being in a position to cut air passenger duty. Given that was devolved, there was inevitably going to be an adjustment, a very small one, a couple of £1 million a year, I think it is. It simply failed as a policy. I mean, it was not enough to make the difference to that long-haul flight. Now, we didn't investigate enough to look at whether the case was plausible in the first instance, that whether it was ever going to be the thing that swung the decision to keep that long-haul flight going or not. But clearly, any policy of that kind, if there is a particular reason like that to keep it, to make it, really does need a pretty good bit of analysis first to convince yourself that it's worth the cost. So that's an example of a piece of devolution that didn't work out as intended. There was a plausible reason for asking for it. Whether it was properly analysed ex ante, I'm afraid we have not looked at in detail.
And I think on that as well, Matthew, one of the key points here is that while we might be paying out 2.3 million annually for the devolution of APT with new income, that's today. I think the research does show that there is a latent commercially viable market for a transatlantic route between Northern Ireland and the US, that does exist. So there's something about how does Northern Ireland PLC go about generating and stimulating the economy enough that it makes that commercially viable market again kick off.
Okay, I mean, on the question of, I mean, it comes back, I mean, in the sense the APD example is, well, to me, it's sort of, it's a piece of fiscal devolution that was done with a kind of tactic in mind rather than a broader strategy. And in order to be successful, it relied on a commercial decision to be made by one or two airlines. So it was kind of slightly doomed for failure. And it was done, but to come on to my next question, it was done based on the prerogatives and of the Treasury. And in the report, obviously, you mentioned today the fact that the Treasury, I mean, currently the Treasury as an institution has never been particularly enthusiastic about fiscal devolution. Jim Alister, quite, as I say, this is a former Treasury official. Jim seems to be quite keen on giving them the benefit of the doubt. I'm not sure I would be in relation to some of this stuff, but as an institution, they haven't been kind of historically keen on fiscal devolution. And I guess the post-2014 Smith Commission is one of the few examples where they've kind of proactively engaged with it. And that was because there was a particular political commitment that was made in a political moment when that was agreed and there was a consensus on that. But at the minute, clearly, that definitely is the opposite is happening politically. So I suppose my question is about, you talked about the need for political choices to be made by the executive. That's definitely true. But is it also the case that it's very difficult to, it will be very difficult to agree on any kind of serious, any kind of substantive fiscal devolution, or even any kind of sort of agreed objective reality around how you talk about this stuff when a political choice has been made to kind of be sceptical about the principle of fiscal devolution, and obviously the letter from the Chief Secretary to the Finance Minister kind of says that. I don't want you to stray into politics. I don't mean to drag people into politics, but I sort of asked you to comment on, I guess, the structure. And at the minute, the UK government, specifically the Treasury, do not seem in any way well disposed to having this conversation.
Sorry, Paul, I'll just make one point on that to say that was the same thing happened in both Scotland and Wales. There was not always political consensus in place ahead of devolution there, nor indeed when their commissions were set up. And in the case of Scotland, with the establishment of the Commencement Commission, the SNP minority government was not in favour of it, and it was established with Labour, the Conservatives and the Lib Dems coming together to put that through. So the consensus wasn't there initially in Scotland. Yeah. Technical committee, as in the same sort of committee that we have here. But as time moved on and it moved into that political space, and the political committee was established, I suppose there was more engagement at that point, and it's easier to find consensus when you have people bought into the process of it.
May I just
I mean, quickly on that one. Since I was involved in the Carmen Commission as a member of the independent expert group, and what Cathy says is correct, I think well, I'd like to say that Carmen, to some extent, depoliticised the issue by showing that for any UK government and any Scottish government, the issues were, and the potentials were, as Carmen set out. And Carmen, I think, was a very careful piece of work. I wish I could say the same about the Smith Committee, which came later. But I think that tells you that your technical commission and your political commission both need to do their job well, in my view.
Sorry, Paul, I think you were going to...
No, I don't really have a lot to add to that other than to say, in a sense, yes, obviously, I mean, devolution of tax powers is in the end in the hands of the UK government to give or withhold, and that requires, that will clearly require a period of time during which the Northern Ireland Executive and the UK government are working closely together on that, if that is the desire.
And I think one positive thing that happened last week, Matthew, was on the back of the review of the intergovernmental relations inquiry that was held, a new intergovernmental agreement appears to have been reached. It was announced last week that there would be a new three-tier structure set up, headed up by the Prime Minister and the heads of the devolved governments. But then at the tier below that, interministerial committees, with one specifically dedicated to finance, that would be looking at these things in a more routine way, and really a reboot of the JMC committees that would have existed of old post-devolution. So there is infrastructure now being put in place to address some of the issues that you've mentioned.
Okay, I'm sure hogging a lot of time, but one final question. Thank you very much. One final question is really around your view of the impact of the impact on the, I guess, fiscal performance generally and financial, and of the use in a Northern Ireland context. We were actually talking about this in our previous discussion in our committee about the use of sort of special circumstances, one-off funding. There's a table in the executive summary which suggests a shortfall of about £500 million between agreed funding, whether it's agreed executive financial packages. This is out with the block grant and what was actually delivered. Do you think that kind of culture of money agreed either politically or there was one party, and again, I'm not asking you to comment on the party politics of it, but the kind of culture of little globules of funding here and there agreed for one thing or another is it's sort of useful or conducive to sort of broader good fiscal performance here?
Well, as you'll see, we've listed in the report the history of that. I think the answer to your question has to be, in principle, no. It's not good for good fiscal management. And my guess, though we've not had this conversation with the Treasury, is that one of the things they would point to in thinking about sustainability is the continual fallback on such one-off pieces of funding. I think one of the issues that we also raise is, I think our presumption would be that if there were significant additional tax devolution to Northern Ireland, then the expectation would be that there will be less of these additional globules, as you call them, of funding, because the assumption would be that the capacity is there to raise the money as needed. Now, I'm saying a lot of that in a sort of in principle sense, because it's very hard, it's essentially impossible to measure that impact. But in principle, that would seem to be the most likely effect.
Okay. Thank you very much. Thanks, Chair.
Okay, Philip.
Thanks, Chair. Thank you. Just like others, can I thank the Commission for the report. It is a useful piece of work, and also thank us for coming along to give evidence to us today. In terms of the block grant adjustments, if we were to get more tax, obviously that's an important consideration for any devolved institution to make. Can I maybe just ask for maybe a bit more detail on the process of how, for example, any adjustments would be worked out? Is it a case that it would be negotiations between Stormont and the British Treasury, or is there some generic formula for working out? What process would you? Would you have a fairly good sense of what the adjustment would be before requesting it, or how does the process of that work out in terms of when and how we would know at each stage of the process what it's likely to be?
I'm going to let Ian do that one. He's the world expert on this.
Thanks for that poison chalice, Paul. It's a very good question, and the answer is not particularly easy because the two examples that we've had so far in Scotland and Wales were really quite different. In Scotland, the negotiations were quite difficult, and that's partly I was a bit disobliging a moment ago about the Smith Commission, but the Smith Commission did set up some guidelines that it would have been very difficult for anybody to follow. Beyond that, it's rather difficult to go beyond what we put in our presentation, that the initial setup is relatively easy. You would just look at what was raised in the previous tax year by the tax that is to be devolved. It's how you index it going forward. And I'm afraid, this is a bit of our report that we have still to write, but if there was an easy answer to give to Mr. McGuigan, we would have done so by now, but we'll do our best between now and publication of final report.
Okay, thank you. And just then, obviously, as you've also said, that there are different reasons why you or any devolution settlement or any what you would want greater taxpayers, greater public spending, or it might fit into policy decisions. And I'm just noting, in your report, for example, you've recommended the devolution of 6 taxes. There are many others that haven't been recommended for various reasons, but I'm just looking kind of at the end of your presentation. You have taxes where there's a case in principle for devolution, but less of a priority. And I'm thinking, there's legislation going through with regard to new gambling legislation. So, would betting and gaming duties taxes be a potential benefit? For example, the public health policy in Stormont might move towards doing something on obesity, but you have said soft drinks levies isn't a strong candidate for devolution. So I'm just wondering why that is the case, that some are recommended when other policies, you might think that they would be better candidates for it. And a couple of others, just, for example, in Scotland, I know that, there has been recommended that devolution of the Crown Estate happens. You haven't recommended that in your interim report for here in the North. And also, I suppose national insurance contributions haven't been recommended. Maybe with specific to that, can you explain the complexities around devolving taxes for national insurance contributions?
Okay, well, there's quite a few there. I think the on the soft drinks levy, for example, I certainly came into this assuming that will be an obvious one to devolve. But actually, because it is active through effectively is effective on the manufacturers of the drinks and is active through the reconstitution of drinks that they put in place. The impact, it would actually be administratively very complex and have very little effect on those things if done from Northern Ireland. Betting and gaming duties, again, the sort of in principle case is pretty strong, but the issues around particularly betting and gaming online and the location of the people doing it makes it quite difficult to do within the differentially within the United Kingdom. So the in principle case in both cases, I agree with you completely. It's just that when we looked at these in more detail, the administrative barriers were more substantive than for example, it appears for the other excise duties on, for example, alcohol and petrol. Although I should be clear, we're not at the point where we've recommended all of these for devolution. These are ones that we feel that there's a case of looking at further, and in particular on the excise duties. That there are clearly some administrative hurdles, and we want to get to the bottom of those rather more. On national insurance contributions, we decided up front, we decided as part of the process that initially, if tax devolution is going to occur, it should be a step-by-step basis, and there'd certainly be a case for one of the big income taxes first, not least because if you were to do income tax and national insurance together, the risks of the two are extremely highly correlated. There's a second set of issues around national insurance contributions, which is their link to, they're sort of largely pretense of a link with benefit receipt, but nevertheless that adds complexity relative to income tax. I think our view would be you would want to start with income tax if you were going to use one of the big taxes on income. We know that that's feasible given what's happened in Scotland and Wales. If that works, if the risks are suitably managed, then at some point in the future you might look at national insurance contributions. So that was the sort of way in which we came at this. But if you look at that list of devolvable in principle, I think if you looked at all of the constituent nations of the United Kingdom, you would say, well, in principle, you could move in this direction. And we know that the Scottish Government, having had control of a certain number of taxes for a while, is now pushing for more. But I guess in a sort of gradualist rather than revolutionary sense, we're fairly strongly of the view that there'll be a large amount of risk associated with pushing a lot of the very big taxes all at once, rather than, as it were, trying some and then moving more gradually.
Can I come in on the question of the Crown Estate, which is very interesting, because again, I can contribute some history here. It was not in the remit of the Calman Commission to look at devolution of the Crown Estate, but when Calman went out into the highways and byways in Scotland, it was one of the questions that came up most often, and therefore, although it's not a tax issue, and that's why it's not been in our purview, it did come into the Scotland Act, either 2012 or 2016, and as members may have noticed, the Crown Estate has just had what seems to be an extremely effective licensing round in the North Sea for offshore wind. So it's a good question, although it was not within our purview. It's a question to raise by other means.
Okay, thank you very much.
Philip, just a question. Do you want to raise an issue for us to write for some clarification on the Crown Estate, particularly with relation to Northern Ireland?
Yeah, I mean, I was going to leave that to the end, but certainly, if we're doing a roundup of things as a result of the presentation, that would be one I think we could perhaps explore. Yeah.
Ian, just for clarity and for the record, wasn't it the Scottish Government got about £650 million for the seabed licensing through the Crown Estate?
That's the sort of number I've seen in the papers, but I don't want to be caught making numbers up or misremembering numbers. But we should all look up the papers and see what the amount raised was.
Okay, thanks very much, Militia.
Thank you for your statement and report there as well. The report draws on comparisons between the two jurisdictions, indicating that the Republic of Ireland has a much higher productivity driven by educational achievement and labour participation rate, with a greater proportion of its economy based on high value sectors like finance, insurance, information and communication. And I just come back to this one on it in terms of the finance, and I'm sure you might have seen just the latest report on that on it as well too, that in the banking sector in the Republic, that they had over 200 billion since the UK voted to leave the European Union. And this was a transfer that leaves Ireland only second place to Germany within the European banking sector at the present time. And with that comes many of the high-paid type jobs that we all are longing for, not only here in Ireland, but I'm sure everywhere else as well too. And I know that the report in itself suggests that the likes of the low rate of corporation tax, and that is an important factor in terms of increasing economic growth in the Republic, but I'm sure it doesn't explain it all. And I'm sure too that the greater proportion, or I'm sure too that for those people will say that have benefit from the educational system, and that in itself doesn't explain it all. And that with fiscal powers being given, we'll say, even out to the Northern Ireland executive in itself, are they ever likely to find themselves in a situation where they're not there, we'll say, like just dependent on the handout all the time, even though there's a question mark there about the extent of that handout as well. But I'm sure it's actually startling, the actual difference in terms of productivity, income earned, even after having paid maybe higher taxes, that is made in the Republic in comparison to us here in the north of Ireland.
I'll on that if you want, Paul. I think some of the things that you've raised there actually do chime with the arguments that are made against the devolution of corporation tax, that competition between regions on the basis of corporation tax to attract inward investment is becoming less acceptable, and that minimum threshold of corporation tax levels that are set to be put in place globally is part of that. So I think there has been a recognition that FDI is not just about the rate of corporation tax in a country, but is very much about the skills and the education base that exists within that place as well, which chimes with what you're saying there, and is something that we have given cognizance to and reflected back in our remarks on corporation tax, that it's much more than just that baseline figure now. It's very much about skills and education as well.
Okay, thanks, Militia. Jim?
Yeah, again, I would concur. Very interesting report, very, very clearly written as well. Sometimes these documents can be a bit turgid, but certainly not in this case. Not remotely surprised at environmental protection in Northern Ireland. We spend a lot less than the rest of the UK, and it's nice to have that confirmed. Nice to have it confirmed, but worrying that that's the case. I agree with Jim Allister, and he says that we may have the nice warm glow of being able to raise extra money, but we inflict the pain on our citizens for no reason whatsoever, because the block grants just reduced accordingly. So, it's the same with European money. If there wasn't additionality, then it really was of no benefit. So I think we need to think long and hard before we go down that route. But just one specific question. For the first time ever, I've seen the aggregates levy itemised at 12 million a year. Northern Ireland has 3% of the population, but generates something like 15% of the aggregates in the UK. We are a huge net exporter of aggregates to the rest of the country, and indeed in my own constituency it's a big employer. Where is that 12 million? Are we just getting back our statutory 3% of that on the Barnett formula, or do we have any access to that money?
The levy will go into the pot, as it were, with all of the other taxes raised in Northern Ireland. So the fact that, for example, income tax is very low in Northern Ireland has no particular impact on the block grant, and equally, if the aggregates levy is higher than per person across the rest of the UK, that will have no impact. I mean, if you wanted it to have an impact, then clearly you would need that devolution, and then the change in the amount that you got from that would depend on how the revenue from the aggregates levy in Northern Ireland changed relative to what was happening in the rest of the UK. So at the moment, no, that does not impact in any way on the Barnett formula.
when it was originally floated and sold to the industry, it was the same as what's called the landfill tax. The landfill tax is a levy on each tonne of waste that goes into a landfill site. That money has to be spent on projects within Northern Ireland, indeed within a certain area within the circumference of a landfill site. And that has been quite successful in generating projects all over the country. That was the initial idea of the aggregates levy, but it simply seems to have disappeared into a hole in the Treasury and never returned. I mean, is that my reading of it? It has all disappeared into the central funds, and the only benefit is that we would get a small proportion of it back, usually about 2.9% under Barnett. Is that, as far as I see, my correct reading of it?
I don't know the history of the aggregates levy. Ian, do you know all on that?
Well, I think initially when it came out, that was the promise, but it has never happened. The idea of the aggregates levy, which applies to Northern Ireland but not to the Irish Republic, and puts our border quarries and sandpits at a severe disadvantage when trading with quarries, say in Leitrim or Cavan or wherever, that the benefit was it was to encourage the recycling of aggregates. That was the whole idea behind it, and that there was a spin-off of additional projects within Northern Ireland. That hasn't happened, or unless I have missed something. But you're confirming it has all gone directly to the Treasury. That's the right reading of it.
Yes, it hasn't been involved, and we did, much like all of the other taxes, in principle, there is a case for the devolution of aggregates levy, but as far as I recall, and we can come back to you in writing on this, I think it was the administrative costs of the devolution of the aggregates levy that took it off our list, that the administrative costs outweighed the benefits that could be achieved from this.
As we produce our written response, I think we can give some history that in the history of tax devolution, the member is right to say that aggregates levy and landfill tax are a pair. One is a tax on making holes in the ground and the other is a tax on filling them up. And it would be logical to consider them together, but there are various practical reasons, including litigation, why aggregates levy devolution did not go forward in Scotland, whereas landfill tax devolution did. And we would be happy to give the committee a note on that, I'm sure, which we could work with our secretariat.
Thank you. Yes, please. Yep. Thanks very much indeed. Jim? Any more, Jim?
No.
Keith?
Thank you, Chair. Thanks, Paul, Cathy and Ian, for your information. And I wanted to just, the booklet is very, very easily read, to be an excellent sort of document you can nearly hand out to any man or woman on the street to understand, so I appreciate that. My question sort of followed on from Philip's. The 20 tax raising powers, and then you've boiled them down to 7, okay? What method did you do that, and I presume you used your own panel, so was that down to the ease of doing it, bringing the tax here, the much money it would raise, and how much influence did the 50 organisations you had that you met or spoke to in your decision-making process in that?
Well, it was a combination of all of those things. In the end, it was a sort of balanced decision along a number of bases. The first, as I said, was when we came to look at this, we looked at the 3 big ones, the ones that really raise substantial amounts of money, and our view was that, at least in the first instance, it would be reasonable to move to one of those, to look at one of those, and frankly, income tax is the obvious one. There are real problems with VAT, for example, in the extraordinary lack of data, which would make that very difficult. I mean, after several years, some of VAT revenues are supposed to be as opposed to be allocated to Scotland, and that's simply fallen at the first hurdle of, frankly, not knowing how much VAT is raised in Scotland, and Northern Ireland is significantly further behind than that. So that's an example of why we would have chosen income tax over VAT. As for the rest, it really was a balance between the sorts of issues that led us to say that, for example, alcohol taxation and petrol taxation should be looked at further. And as I said earlier, you might think exactly the same arguments in principle would relate to the soft drinks levy and betting and gaming levies. But having looked in considerable detail at these, it was clear that there were substantially additional administrative and practical barriers for the second two than for the first two. Though, as I say, we're going to look at those. We're going to look at those in more detail. So it was taking account, as I put out on the slide, issues around the accountability, the economic context, the political capacity, and all of those sorts of things. In the end, reasonable people could have come up with a different list to take forward, but I don't think it would have been a massively different list. And frankly, I mean, I think the last thing which we had in mind in all of this was both our capacity in a year to come up with clear recommendations and a strong analysis, and the capacity of the executive to take on more than a certain amount early on. I think the indication we're giving with that long list of devolvable in principle is something that I would hope both the Westminster government and the other devolved administrations would look at and think about for the longer term what could be possible. I think one of the things that really struck me in doing this report was that in principle over the longer run across the UK there's more scope for devolution than we have at the moment. But as I've said a number of times, the administrative, practical complexities, political complexities, and risks associated with them would make it sensible to take this at a pretty gradual pace.
Okay, and just one final question.
Yeah, go ahead, Keith.
Chair. With respect to the apprenticeship levy on your little slides, that was the one you had no figure against, and I was reading in the document, but I just can't get my hand back on it. There's an indication from memory between 30 and 80 million. Am I correct in saying that? But is there not an exact figure of an apprenticeship levy?
Sorry, I missed the question.
So on your slides, Paul, slide number 27 in our booklet, the one with the figures against income tax, fuel duty, stamp duty, tax, air passenger duty. There's no figure against apprenticeship levy. But in your report, it indicates that it's somewhere between 30 and 80 million. Why can you not get an exact figure of the apprenticeship levy from here? Or what's the reason it's not there?
I honestly can't recall the details of why we didn't have an exact number for the apprenticeship levy. I mean, the reason that it's there in the way it is that our view is that you would only devolve the apprenticeship levy if you're also devolving income tax, because the additional administrative complexity that might be associated with just the apprenticeship levy wouldn't be worth it. I think we can get back to you on the question of why the number is so uncertain. I'm afraid, off the top of my head, I don't know the answer to that.
So I found it it's in your main report, page 156. There's different estimates of figures, but I appreciate you don't have an exact figure because you obviously haven't been told it. No, that's fine. Thank you. I'd appreciate if you could get that. It'd be good to know that, Paul. Thank you. Thanks, Chair.
We'll ask the question as well. Okay, we'll ask the question as well, Keith. Thanks. Paul, team, thank you very much. Just a few final questions. First one, you'll be aware of the correspondence from the Minister, and indeed I think it's been agreed by the Executive as well, to the Chief Secretary of the Treasury, inviting the Treasury to become engaged with the Fiscal Commission. Have you had any update on that? And bearing in mind the august team that you are, how did you think when you saw that correspondence from the Treasury? You didn't think you were the appropriate? They shouldn't be fully engaging with you.
Well, it would be helpful to us if we got more engagement, particularly on some of the technical issues that we're dealing with. In the end, this is a political decision that has been made by ministers in the Treasury, and I certainly wish the Finance Minister well in trying to get more engagement in this conversation, because I think at the very least both our report and the existence of the Fiscal Commission indicates a degree of seriousness within the executive, which it will be good to see reciprocated.
Did you have and I know, I think I read in the report you didn't have similar issues with Scotland and Wales, but was there any sort of sense that there was a bit of feet dragging coming from the Treasury on any of the previous work that was being done, do you know, for the other devolved administrations?
Ian, I'll defer to you on that.
Some of the history has already been given earlier in this session, that the Scottish Calman Commission was set up as a joint project of the UK government at the time, which was the Labour government, and the Scottish Parliament, with the SNP, which was at the time a minority government, voting against. And so there was buy-in from UK government at the outset in the case of Calman and Scotland. In the case of Wales with the Hulton Commission, it was more detached, it had less status, if you will, with the UK government, except that, again, it was a project of the then Labour administration in Wales, and there was a Labour government in the UK, and so the government-to-government relations were fine, as far as I'm aware, in the case of Hulton. The politics is very different this time, and like my colleagues, I don't really want to go any further in speculating why and how it's different or what should be done about it.
Okay.
I don't know that.
We'll do the political tweaking from this end. But thanks very much. Sir, the final question, Paul, is timelines. As you're aware, we rise. I think it's on the 28th of March. That's it. That's it for this, and it'll probably be a bit of a while before. Not preempting anything, but I think it'll probably be a bit of a while before we get any form of government formed thereafter, after the elections. So, what's your timelines for the report?
Well, we're to some degree we're still discussing that. Our remit was to publish before the 28th of March, essentially, and that's certainly what we aim to do. We've left ourselves quite a lot of work to get done over that period, but our intention is to get it done within the next couple of months.
Okay. Paul, Ian, Cathy, thank you very much indeed for your hard work. And Cathy, you notice I didn't even ask a cheeky question about why University of Ulster is stealing all our FTC. See that? See how good I was? How well behaved I was?
I want a career break, so no questions on us at the moment. My focus is firmly on Fiscal Commission work.
Okay. And just finally, because I think the BBC have taken a bit of interest in what we've been doing today, I would encourage everybody to have a very good look at this, because, look, it's not often you get a document that comes in front of the committee, or indeed of anything to do with Northern Ireland, that is actually not only readable, but actually gives all the necessary information in the right place. And I also sort of push a plug for the Fiscal Council as well. Both sets of documents, I think, have been very well received by this committee, and it has helped inform debate. But thank you very much indeed, and thank you very much indeed for your hard work. Okay, looking forward to the final report, team. Thank you.
Thank you.
Thank you.
Okay.
In summary, Chair, so we're writing to the Fiscal Commission seeking clarity on the aggregates levy and the apprenticeship levy.
Mm-hmm. Is that the Fiscal Commission, or is that to the Department for Finance?
That's to the Fiscal Commission, but we're also then writing to the department about the Crown estate.
Yeah. Well, no, actually, it does probably fall within the Department of Finance as well, because they're the governmental solicitors. Because the Crown Estate has responsibility for the seabed out from the high water mark to sort of the territorial limits. And again, one of the things that was in Scotland, it was devolved, and they did get substantial amounts of money for when the seabed was leased for the wind farms. So actually, it's probably quite a good question to ask on where does the ownership of the Crown Estate, particularly to do with the seabed, where does it lie?
Okay, I have a feeling, Chairperson, this question appeared previously about Lough Neagh, but anyway, we'll ask the question of the department in those terms, if that's what members are.
I don't think Lough Neagh is privately owned, isn't it?
Yeah, it is.
It is. Yeah, it's not owned by the Crown Estate.
Oh, okay.
Yeah.
I own it, but
May I defer to my honourable member from that on the other side of the loch? Okay, thanks very much indeed. Are we in a position to go to the LCM and public sector pensions?
Yes, we're at agenda item 10.
Agenda item 10. Is Colette, Blenhead and Stephen available?
They are, I think. Yep. There we are.
There we go.
Right.
Hi Colette, hi Blenhead.
Hi.
Hi
Hello.
Stephen, welcome. Team, moving on to the next item on the agenda. It's the LCM on public sector pensions. The committee will now receive an oral briefing from departmental officials on a further legislative consent motion relating to the Public Service Pensions and Judicial Offices Bill. We're welcoming Colette, Blainad and Stephen, Acting Director from the Pensions Division, Assistant Director and Public Service Pensions Policy and Legislation Branch. Members, following papers related to the agenda items, briefing papers on 454, previous related correspondence is page 463. A copy of the committee's report on the first LCM is on page 465. On page 38 of tabled items, the Department has provided a response on the impact on retirement levels of the reforms to public sector pensions. Team, you're very welcome to the Committee for Finance. We have invited you to the meeting to provide members with a briefing on a further legislative consent motion relating to the public sector pensions. Apologies for you're hearing the division bell going off. We're still, hopefully we've got a bit further down the stream on the current integrated education bill, but that's where we are at the moment. Colette, are you speaking to this, are you?
I am, yes.
Okay, over to you, please.
Okay. Mr. Chairman, thank you for the opportunity to update the committee on the proposed second legislative consent motion for the Public Service Pensions and Judicial Offices Bill. As set out in the Department's written briefing to the committee on the 14th of January, this LCM would implement changes to the cost control mechanism for public service schemes, which were recommended by the Government Actuary in its 2021 report on its operation. These additional cost control amendments laid on the 6th of January 2022 technically fall outside the scope of the original LCM agreed by the Assembly on the 1st of November 2021. The scope of the original LCM was to allow the measures in this bill to remedy age discrimination in public service schemes to extend here. That LCM did include some changes to the operation of the cost control mechanism in order to ensure scheme members suffer no disadvantage from any cost cap breach occurring as a consequence of the inclusion of remedy-related costs in the 2016 valuations. These additional proposed changes are not connected with the remedy in the same way. They will also apply only from the 2020 valuations. This is a reason a second LCM is required. The cost control mechanism was introduced for public service pension schemes, both here and throughout the rest of the UK in 2015. It is part of the package of public service pension reforms which were recommended by the Independent Public Service Pensions Commission in its 2011 report. Two of the main objectives of the mechanisms are: one, to protect the Exchequer and by extension taxpayers from unforeseen costs, and two, to provide stability and certainty for members on benefit and contribution levels. At the 2016 valuations, it was observed that projected 2016 valuation outcomes were indicating both breaches of the cost cap floor and increased costs for employers. This raised concerns the mechanism was not operating in line with its original objectives, and the Treasury commissioned the Government Actuary to review its operation. The Government Actuary's report recommended a number of changes to the mechanism which would address these concerns. Following a consultation which included stakeholders for the devolved schemes, on the 6th of January, Treasury laid amendments to the Public Service Pensions and Judicial Offices Bill to implement two of these changes. The Department wrote to the Committee on the 12th of October 2021 on the outcome of this consultation. A summary of the two main changes are: one, reformed scheme-only design. The change to a reformed scheme-only design would remove the effects of the pre-reform, i.e. legacy schemes, from the cost cap mechanism The government actually had identified change in these legacy scheme costs were the main driver for the cost floor breaches indicated in the 2016 valuations. The reform scheme only design will address this concern and will ensure consistency between the set of benefits being assessed and the set of benefits potentially being adjusted for the future. This will make the mechanism more stable and reduce intergenerational unfairness, because comparatively younger members' benefits or contributions will not change based on the cost of legacy schemes they had little or no access to. Under this approach, the cost risk of the legacy schemes would pass entirely to the Exchequer. The LCM will ensure this also applies for devolved schemes. Second change is the economic check. The change for the economic check would introduce a new step in the valuation process to evaluate any cost cap breach before any resultant scheme changes can be implemented. The introduction of the economic check means that the impact of a change in long-term economic assumptions would be considered in the cost control process and is able to offset any ceiling or floor breaches that would otherwise occur. It is worth noting the effect that changes in long-term economic assumptions can have on the mechanism is limited, because it cannot cause or contribute to a breach, but only prevent or offset one. The LCM will ensure that the devolved schemes implement this economic check in the same way and to the same timescales as the equivalent schemes in the rest of the UK, and in line with overarching requirements of Treasury cost control policy for all such similarly constituted public service schemes. Chair, I hope this brief overview of the two changes this LCM would deliver has been helpful. I appreciate they are technical changes. However, it is important that their impact is understood. As set out in the more extensive briefing paper provided to the committee, the design of the devolved public service schemes is broadly identical to that for equivalent schemes in the rest of the UK. These pensions are paid from AMI, and as a consequence, cost control policy for the devolved schemes is expected to reflect that maintained by Treasury for those equivalent schemes. Adopting these proposals for devolved schemes is therefore necessary to maintain this approach. To do differently would lead to divergent valuation outcomes at the 2020 and subsequent valuations. This could potentially have implications for available block grant funding if additional funds are needed to cover shortfalls in circumstances where devolved scheme costs could exceed the comparable cost control profile for the equivalent schemes elsewhere in the UK. On this basis, it is important that these changes are applied for devolved schemes here to the same timescales. There is no legislative vehicle in the Assembly currently which could bring these amendments into effect at the same time as for equivalent similarly affected schemes elsewhere. In these circumstances, the LCM provides the most practical solution to ensure they are made in line for the completion of the 2020 valuations. The timescales to secure Assembly approval for this proposed LCM are also challenging. An LCM for these amendments would need to be agreed by the Assembly by report stage for the Public Service Pensions and Judicial Offices Bill. The report stage is the final point at which the bill amendments can be made. If the LCM is not agreed, the draft clauses which would implement these additional changes for devolved schemes must be removed at this point. Treasury has indicated this is currently expected to occur week commencing the 7th of February 2022. These timings would require urgent scheduling for an Assembly debate subject to executive approval. This matter will be considered at tomorrow's executive meeting. The Department has discussed scheduling of the second LCM with LPS and is seeking to have a motion tabled under Standing Order 42A9. Chair, my colleagues and I are happy to take any questions.
Okay. Look, you've answered the question of, if we don't pass this, we'll be into another separate parity issue, and then we'd have to find it from alternative sources. So I've got that as well.
Back.
Okay. In recent correspondence, you confirmed that under the public sector pension reforms, some civil servants who might have been planning to wait until retire until the state pension age will now be able to receive their full final salary public sector page at age 60. I think this comes from this. Sorry, apologies, we're still in the midst of voting. Your correspondence suggested that this will have no impact on the rate of retirement in the Northern Ireland Civil Service. Could you give us a bit of explanation on that, please?
That's slightly different to the need for this LCM. That's,
no, but it's why we've got you here.
Okay. Sorry, could you repeat that question again then? It's to do with the age 60?
It's been tied up quite a lot with what we've been doing particularly about sort of the public sector pensions and this issue to do with this particular issue where we're at the moment. And there's a question that sort of we have been, with public sector pension reform, some civil servants who've been planning to wait until they retire at state pension age, they're now going to be able to go at 60. Okay, so obviously there's a difference of 7 years there. The correspondence we've had from the department in your sector suggested that this will have no impact on the rate of retirement in the Northern Ireland Civil Service. So obviously, if we've got more people from the Northern Ireland Civil Service who will see this, we'll see these changes coming through and say, right, okay, it's coming at 60, I need to go now. But you say that you don't see that's not going to have any impact on this?
To date, within the Northern Ireland Civil Service, we have received no significant increase in numbers of leavers. Now, we won't be the first port of call. It will be line managers and through HR Connect and all of the HR process. Then we in civil service pensions would get notification of leavers. But we keep stock of all of, people sort of apply for retirement around 6 to 3 months before they're looking to go. And to date, we have seen no significant increase. In fact, even last month, we had some people withdrawn their retirement applications. There was never any reason why a person who had any final salary benefits couldn't go with a normal pension age for that scheme and take those benefits. So someone who still remains in the protected group and move over to the Alpha scheme in the civil service on the 1st of April 2022 can continue to work on to whatever age they wish to work on to and get their full final salary benefits without actuarial reduction, and then they can either preserve their Alpha benefits that they've accrued until state pension age or take their Alpha benefits when they actually do leave with a small actuarial reduction depending on their age. They have various options when they do go.
Okay, thanks. Jim, do you want to come in?
I suppose I should have declared that I'm the chair of the Northern Ireland Assembly Pension Scheme, which is tiny in comparison to the sort of figures that the department's dealing with. After a bit of agonising, we decided as a committee and the Assembly to back the first legislative consent motion. I think we really didn't have much option, but I have to ask the question, could this issue not have been foreseen at that time? Why the need for a second LCM?
The need for the second LCM it's down to the actual timings. The commissioning of the GAD report, the consultation exercise that had to take place, and then the whole process of agreeing what changes would be brought forward from that consultation. And that all just took part from October onwards. So that the first the Treasury laid this was on the 6th of January. And that was the vehicle that they would use because they needed a primary legislation vehicle to bring forward these amendments.
And then we've been told we have to get it all through by the first week of February. Is that a reasonable approach? You told us that it has to go before the Assembly by the 6th of February.
We are trying to use the clause of 42A9.
42A9. Yeah, accept that, but I mean, we're now, the 19th of January, and you're using sort of accelerated passage on steroids here, because this is all going to be rushed through within a month between it becoming public and becoming law.
There are options. The only thing is that there's a risk with the other alternative options.
Yeah, I mean, I know where you're coming from, but and we did accept the principle, and it was a difficult one because we had some pensioners saying to us that it was very unfair what was being proposed, but basically we were told that if we didn't toe the line, and I agree the LCM, the Department of Finance would have to pick up the tabs if there's any extra expenditure. Now you're telling us that not only is there a second LCM, but it has to go through in record time. Is the 6th of February the absolute last date that we can agree this?
We're continuing to liaise with Treasury on this matter, and if there's any change to date, we'll keep yourselves informed.
And is there any other legislation being considered coming through on top of the first two LCMs?
Not that we are aware of.
Right, okay.
Sorry, just for clarification, sorry, apologies, Colette. So the reason why this has been brought back to us was the information you've only received from the Treasury?
That's correct.
Okay, and you only received that in January, or earlier on this month?
We received confirmation that they were making and laying these. They debated it on the 5th of January and laid the amendments on the 6th of January.
So the amendments were made on the 6th of January, so therefore the subsequent from the need for the LCM sort of came from that?
That's correct.
Okay. And it's been tabled for the executive tomorrow?
That's correct, yeah.
So what happens if the executive, if it doesn't get on the agenda, because it's a fairly busy agenda, I would imagine, tomorrow, and if it's delayed, what is the last possible date we have to get this through?
What you want to?
Well, currently it's report stage in the Commons, which is provisionally scheduled for the 7th of February. If we were not able to get an LCM through by that time, we would have to have our provisions within the amendment removed at report stage. The timings are very tight in Westminster at the minute because they need to receive royal assent in March to enable the scheme regulations to be made to close the legacy schemes for prospective remedy. Right. So the decision was only made to lay these amendments on the 6th, and we have taken every step we can since then in order to progress this, but are really tied with the progress of the Westminster legislation. Westminster would like to have royal assent, obviously, by the 11th rule for the making of the regulations for prospective remedy.
11th of March. Was that 11th of March or 11th of February?
We couldn't hear you.
11th March
Okay,
would
sorry,
be.
you broke up
That
again,
would be.
We couldn't hear.
Lost you again.
Lost you again.
Okay, right.
It was the 11th of March, but it's at the 11th of March.
11th of March. Okay, thanks very much indeed. Members, are there any other further questions we'd like to sort of raise? Okay. Team, thank you very much indeed. Colette, Sarah, Blanid and Steve, thank you very much indeed for coming and doing that as well. Thank you. Okay.
Okay, thank you.
Chair, just want to come back to me for a second, if you would.
Yeah.
Chair, just the department there mentioned Standing Order 42A9.
Sorry, apologies to the committee. I wasn't using my usual attention. I was conversing with Peter because I wasn't quite familiar with that, so we were just reading the rule book.
Actually, neither am I, honestly. But what it also indicates, I think if I read it correctly, is that the committee is not obliged to report on this. So what happens is a legislative consent motion was put through in September, October, as the member will recall. The committee commented on that and all that. It got to Westminster. They then amended. In Westminster, they amended. So a further legislative consent motion is required, but in those instances 42A applies, and under 42A9 there isn't a requirement then for the committee to report. Now, the chair will probably want to speak in the motion, but we don't have to produce a report. So that means it's not just as, in terms of timescales, it's not just as crazy.
I presume there's no consultation with anybody with this apart from ourselves?
My understanding is that the CCWG, which is the Joint Consultative Working Group, the unions were consulted about this. They expected this, my understanding is they expected this to be done in regulations, so they weren't expecting a legislative consent motion. But I've had a chat with them and asked them to provide written or oral evidence for the committee next week, so the committee could make up its mind next week, but we don't have to produce a report.
But I think it would be appropriate if if the committee are content, I think it would be appropriate if I made some remarks, but I think it's appropriate, you've written to NIC, ICTU to try and get provide oral or written evidence to this, on this legislative consent motion. So I would like to see what they say about it, if we're content. Everybody agreed? Okay, thank you very much indeed. Thank you. Move on to the next item on the agenda, which I think is back to correspondence.
11.8.
11.8, housing benefit transfer. The committee has asked to note at page 516, response from the Department of Finance to committee queries advising that the housing benefit relief will not transfer from LPS to the Northern Ireland, to the Northern Ireland Housing Executive. It is also likely the transfer will now be to the landlord, or not be to the landlord function of the Housing Executive, which may be mutualised. So where's it going to?
It's going to the other bit of the Housing Executive.
Whatever that's going to be called.
Bit. Yeah.
So when are they proposing to do that? Because that hasn't happened yet.
In terms of the transfer, May 2022, but the mutualisation, I think they're still thinking about that. So I don't think there's any legislation yet, or maybe wrong, but I don't think that hasn't happened yet.
So it is going to, just so I get this right, it's going from LPS to the Northern Ireland Housing Executive in May 2022, correct? And then at whichever point that there is a mutualisation of part of the Northern Ireland Housing Executive, the bit that stays with government in big handfuls, that's where the housing benefit will remain.
Yes.
Okay. Right. And do we know whether Northern Ireland Housing Executive, what their perspective is on this?
I understand that this the stat rule has also been considered by, in fact, it was most of the consideration was done by the Communities Committee. So I couldn't tell you, but I know that committee has considered this stat rule.
Okay. Should we just drop a note to the Communities Committee just to ask them whether they're content, whether the Northern Ireland Housing Executive, whatever, has the capacity to deal with this? Because remember, the problem was that LPS wasn't able to deal with it, and it was raised by the report from the Auditor General.
I think the stuff from the Auditor General was about housing benefit relief.
Yeah.
That was where they qualified their accounts, but that isn't going from LPS, that's staying where it is.
Right.
The other stuff is housing benefit itself, which is going to Housing Executive land, which sort of makes sense. As they are, they are what they are.
Maybe just write to the Department or the Communities Committee, just to see that they've asked the Northern Ireland Housing Executive whether they have the capacity and the ability to deal with this. Because obviously there would have to be transfer of personnel as well to be able to deal with it, because housing benefit is quite a complex issue. Okay. Are we content on that? Great. Charitable exemption. Again, this is something I raised my interest on earlier on. The committee is asked to consider on page 518 and at page 43 of tabled items correspondence from the Reserve Forces and Cadet Association for Northern Ireland querying the treatment of cadet organisations for the purposes of non-domestic rates charitable exemption relief. The issue here is that in England and Wales, not quite sure about Scotland, Reserve Forces accommodation is treated as for charitable relief, yet here in Northern Ireland it isn't. And it's just a question to ask of the department to seek clarity in this issue and why this is particular king. Are we agreed?
Yep.
Agreed. Next item, support for pensioners. The committee has asked on page 519 a copy of further correspondence from a concerned individual's department in respect of Northern Ireland Housing Executive repair grants. Are we content to note this correspondence? Noted. Agreed. Thank you. The Northern Ireland Chamber of Commerce and BDO Quarterly Economic Survey Report. for the fourth quarter 2021. Are we content to note this correspondence? Agreed. Domestic and sexual abuse and violence strategy. Members are asked to note joint correspondence at page 543 from the Executive Office, Department of Justice and Department of Health, calling for views to inform the development of 2 domestic abuse and violence against women strategies. Are we content to note this correspondence? I think we are. And the composite information request is at page 545. Is the committee content that the composite request is an accurate and complete record of the committee's information request? Is this agreed? Agreed. Thank you. Moving on to draft forward work programme. A draft forward work programme is at page 566. Are members content with the forward work programme as drafted? Agreed. Yep. Any other business? Nope.
Mr. Wells.
I think the gentleman controlling that bell is paid by the bell, paid by the time, because there can be no justification whatsoever for the number of times that bell has been rung during our committee. I understand from the clerk that we can't actually switch it off in this room, but as I think most of us will, this is going to happen again, of course. As all of us have given our votes on proxy to somebody else to vote for us, we don't need to be informed of the divisions. So there must be some way of cutting off the speakers in here.
Apparently it's linked to the fire alarm, so they can't. Yeah. So I've been texting throughout the meeting about this, and I think the clerks at table promised that they would ask whoever's in the chair to please not use the bell just so often. I think it has got, it reduced a wee bit now.
It has, right, but I would like to see it at full tilt.
On that joyous note, team, next meeting in here on Wednesday, next Wednesday the 26th at 1400. Thank you very much indeed, and thank you very much indeed for a particularly productive committee meeting, and thank you.
Thanks, members.
Assembly, Senate Chamber.